For correction of typographical mistake in my lordship's order, let it appear as document. I am grateful, my lord.
Corrections, please hand over the slip.
Lordship, for upgradation,
Upgradation, please come on Monday.
have a lordship's kind leave to file without on lordship. Tuesday, lordship, for passing.
Please come on Monday.
Lordship,
May I have
without certified copy, my lord, order passed day before, uploaded yesterday. Interim order was till Sunday, directing me to, my lord, make payment of security of 35 lakhs apart from occupation charges.
And
Lordship, I'm mentioning
My lord,
the strategy.
yes, Mr. Chatterjee.
may I have my lord's kind leave to mention, my lord, an extremely urgent matter. My lord, what happens is, this is again Public Premises Unauthorized Occupants Act. My lord was pleased to stay the matter, my lord, in under the Section 4 proceedings. What they did was, they gave us one date and stopped the entire proceeding and said they will pass orders. Your lordship stayed it. Now, my lord, what happens is, they have issued a notice under Section 7. Same thing is going to happen. So we challenge the notice itself before your lordship, my lord, in terms of an order.
All right, file it. It will appear Monday.
Your Lordship, if I may kindly be without certified copy. We have the original file.
Without the certified copy.
We have the original.
But you have the copy of the order.
Yes.
Yes.
Certified copy order uploaded, order dated 31st of July, still certified.
What is the urgency?
Urgency is, my lord, Monday is the date fixed for written arguments, my lord.
What is the order under challenge?
My lord, order, my lord, I have prayed for certain certified copy of the transcripts because the cross-examination was done through video conference.
Your Lordship, if I may kindly be permitted to mention upon notice, my application is for extension of interim order. It has mistakenly been put under the heading of application. It is running as item number.
Mention on Monday. Yes.
Led by Mr. Chatterjee,
My lord, there's another extremely urgent matter, my lord, here. My
All
lord,
matters extremely urgent, Mr.
I-
Chatterjee.
I would not have troubled your lordship. My lord, this
No,
is
you have to choose which one to be listed.
my lord,
Now you have to choose.
both are very urgent. Now, here what happens is, my lord, the mean profit proceedings have started. The degree is of 1986 compromise degree. Now they want to, my lord, have mean profits. And
No,
anything, my lord,
that's not urgency, Mr. Chatterjee. Please file it. It will appear in due
we'll
course.
file it, my lord, if it kindly, my lord, fixes it
No,
on
no, no, no.
file
Not
it.
on Monday. Yes.
On
Not
Tuesday.
on Monday. All matters, Mr. Chatterjee, it will be difficult.
Achha, very good. I'll file it, my lord. I'll file it, my lord, and
From
hand
Yes.
over
From
the-
combined list, my lord, 138. This is 1031.
Upgradation.
Upgradation.
Mr. Ghosh,
My lord,
please
it was
mention on
motion
Monday.
never taken up before Justice Omnaran Rai. It was
Please
filed.
mention on
But it
Monday.
has gone down.
Mr. Ghosh, I have refused all because last Monday many slips were handed over, so I have considered those. Please mention on Monday.
78 of today's list, my lord, this was an interim order passed by your lordship. It's the Vidhannagar Municipal Corporation matter, my lord.
Yes, item 78 interim order is still today. Let me see how far I can proceed.
I'll come back at 1:15. I'll
115 or 425? Yes, call the list. Yes, call the list.
He appeared on the opposite party. I do not know why it has come under the head release. Oh,
Trying to take up this matter on personal ground. This matter stands.
Same
Order. Next. Same order next. Yes.
Custody matter, but the district judge Alipur has no jurisdiction. Last time, Lord.
Who is opposing you?
Mr. Rai.
Parthapratim Rai is leading me.
Where is he?
He is in some personal difficulty.
Personal difficulty. Then Mr. Ghosh, are you opposing?
Last occasion also, Lord, daughter, my daughter is suffering.
My lord, they have,
daughter.
my lord, kindly please.
Mr. Ghosh, are you opposing the prayer for accommodation?
Monday.
Monday, my lord, we
Lord, he has come
have to
from
engage
Bengaluru.
someone, my lord.
Uh,
My lord, we have to engage someone.
Monday.
Monday, not possible, my lord. Monday, not
Why?
possible.
You are getting the weekend. Today we are on Friday.
We need some time, my lord. We need some time.
How much time?
1 week's, at least 1 week's accommodation. my lord.
The last occasion also, you Lord, on that ground.
Mr. Ghosh, today is a different day, Mr. Ghosh. An accommodation has been spot. Yes. Yes.
For opposite party.
Same order next. Yes.
I'm for the opposite party.
Yes.
But my lord appeared, my lord.
It appeared.
Lord,
Yes.
my application, Lord, for extension of interim order. Lord, we have served, Lord. Lord, may I find?
The file an application for extension. When did it expire?
It expired in the month of March. But before that, the application was.
What is the impugned order, Mr.
The
Spal?
impugned order is not by 7172 rejected. My Lord has granted it.
So what?
But I'll indicate the reason. The Lordship takes not 23rd of June 2025 order the Lordship had recorded. Page 7 of my application. The issue was not order 9 rule 13 allowed. Now not order 9 rule 13. Huh. What?
Mr. Kormakar, I think this was admitted at a point of time. 7-day Adventist was pending.
Yes, but here also.
Now it has been decided.
But then also, Lord, my case is, Lord, I do not think, Lord, I am prejudiced by 7-day Adventist. The reason is.
No, but on that ground, you got it admitted.
Order 9 rule 13 was, Lord, kindly consider this. Order 9 rule 13 was allowed on the ground that summons were not served. Thereafter, I entered appearance. From the date of appearance, within 1 month, I filed, Lord, this application.
Mr. Mukherjee, if that is the fact, then can that be rejected on that ground? What Mr. Kormakar says, I have not gone to the papers.
Your Lordship will kindly go through the papers, allow us to submit before the court and in details, and that will clear up the
Mr.
situation.
Mukherjee, if that is the fact, if
I don't think that is the fact. If your Lordship kindly goes through the order which has been passed by the learned trial court, it will be clear what is the actual situation.
I'll give your Lordship the dates.
The order, your Lordship, is annexed to the application. Lordship comes to page 2 of the order, impugned order. May I
page
read
2,
it? May I read it for the
No, Mr. Kormokar.
My lord.
Admitted amount you did not deposit it along with 7-2.
That is what I'm saying.
7-1 and 7-2 were filed.
That is what I'm saying.
Mr. Kormokar, whatever it might be, you are obliged to deposit either 7-1 or 7-2. If you are disputing, you have to deposit the admitted amount or the entire arrears on the day of appearance.
But Lord, 7-1 was filed. Lord, until and unless 7-1.
Mr. Kormokar, that's neither here nor there. There is no provision for only
Dispute the
filing.
7-1.
You have to deposit the amount, and moreover, 7-2 you have filed without depositing the amount. It requires that
I tell you, Lord,
7-2 you have filed without deposit. That's the finding.
Lord, 7-1 and 7-2 was filed on 24th of July.
Yes,
Lord, deposits were made on 3rd of August.
could not have been done
3rd of
because you ought to have deposited on that. 3rd of August is within 30 days of that.
3rd of August is not from 30 days from
Then-
30th of
then-
is not there. But
then-
what I am indicating is that 7-1 and 7-2 was pending. And I
Mr.
filed 7-1
Mr.
until the 7 was
Mr. Kormokar, you ought to have filed on the, you have to have deposited the amount within that time, 30 days.
difficulty is not
30 days you ought to have deposited
unless 7-1 is allowed.
because on your, you were aware of that, on your application, the ex parte decree was set aside. After setting aside the ex parte decree, a date was fixed. A date was fixed for appearance.
From
So
that date, 1 month.
from that date, 1 month, even that should not have been that date. So if, yes, because you were having the knowledge that the ex parte decree is being set aside.
Lord, it's
So,
from the date of appearance. The statute says from the date of appearance. The appearance.
Without service of summons, now it's a case.
Yes.
Mr. Because on your application, it was set aside. So all things cannot be brought on that straitjacket formula. If you want, I can interpret that on that. But without going to that, even taken a lenient view, even from that date of appearance, you have not deposited within 30 days.
My subject to Lordship is not 7-1 was pending until and unless 7-1 is disposed of.
It's not.
What is falling from your
No,
Lordship?
Kormokar, that's neither here nor there because there's no, the statute do not contemplate filing of an application. What was required was you have to deposit that amount. And also, even if you are disputing in 7-2, in none of you have filed both the applications, so you have not complied with either of the provisions.
Waited for the order to come, Lord, in 7-1.
So
So that was the
earlier round you have succeeded.
that was
So
the practice.
ex parte degree, you wash from the fence. Once you have succeeded,
No, I succeeded.
so now it's
Sir,
all times, Mr. Kormokar.
but I succeeded because I was.
You have taken that risk. This time you have taken the risk.
This is not a risk. This is not. The problem is not that until I filed 7-1, waiting for the order to come for 7-1. That's the.
That's neither here nor there. There is no necessity. There is no necessity to pass an order. There is no necessity to file an application either.
Now, Lord.
And even if I go by that 7-2, you have also not deposited the amount. Admitted amount you have to deposit. That also you have not done. So your conduct is not bona fide.
Lord, may I come back on Monday?
Why? How will you improve on Monday?
If I may try and
It's a different date.
That day sun will
Someone
come.
has told
That's
that.
a Sunday. That might be a sunny day. For my matter also. May I come back on?
Yes, I'm not extending. I'm keeping it under the
But
same
if it's
heading.
pending, let me try my Lord. If I may try and convince your Lordship.
Come back on Monday.
Monday.
I will be deciding the matter
As you lordship.
finally.
Sunday, Tuesday, that.
আচ্ছা করে দিন একটা লাইন
On behalf of the petitioner, my lord. I beg to appear on behalf of the petitioner, my lord. The interim order, my lord, has expired. My lord, I will be humbly beseeching if your lordship kindly takes up the matter for hearing. My learned friend is there. My lord, last occasion also he was there, but the interim order was extended.
What is wrong in this order, Mr. Sood?
My lord, no.
Willing
my
to
lord,
adduce
just-
evidence
No, my
that
lord,
is
the argument is closed. If your lordship, I will be just placing before your lordship two previous orders.
arguments were made. The court found that for the ends of justice,
lord,
this is
for the ends
necessary.
of justice, but
All right, I am extending, I am fixing. After hearing the
I'm for the petitioner. Well, this is, well, I'm the plaintiff in this plaintiff petitioner. Well, this is against an order, well, allowing the application under section 5, read section 8 of the Arbitration Act, my lord. Well, after submission, well, after before the court, my lord, he has filed an application after 1 year from the date of receipt of the summon, an application under section 5, read section 8 of the Arbitration Act. And my lord, I shall submit, I shall place the order before your lordship, order passed by the court. Their ex parte order was recalled. That
ex parte of,
ex parte hearing, my lord,
yes,
after filing an application, my lord, your lordship kindly see, my lord,
arbitration and conciliation actually. এখানে আছে?
my lord, I am placing one after another order, my lord. My lord, your lordship kindly come.
Please give me a minute.
1 year after date of receipt of the summons, my lord, this application has been filed. Before that, they filed application for adjournment for filing the written statement. Now, that is the order of the court, my lord.
No, they have they filed their first statement of defense.
Defense has not been filed, but no,
That's the outer limit, mister.
no, my lord, your lordship kindly consider, my lord. They have filed petitions that they would file the written statement.
Yes, but written statement, the language says before the written statement is filed.
No, my lord, your lordship kindly say I've got one judgment, my lord. Another,
Yes.
my lord, your lordship.
Yes. If it says if it is prayed that a written statement will be filed, then section 8 cannot be filed. Please show me.
My lord, they
Please
submitted
show me the
the
judgment.
jurisdiction.
What judgment you are trying to rely upon?
Paragraph 21, my lord. My lord, another thing, my lord, I shall place the arbitration clause, my lord. This is also void, my lord, because, my lord, it hit under section 12 of the Arbitration Act.
Paragraph 21.
Yes, my lord, paragraph 21. My lord, that will be evident from the orders passed by this court that I want to place before your lordship one after another.
How does it help you? They are in the written statement, this point was taken. After the written statement, they filed a counter claim.
Yeah,
They
my lord, that is
proceeded.
natural, but
They are
what-
after this.
my lord,
This is
your
a
lordship
distinguishable on facts.
my lord, your lordship kindly allow me to place, my lord, some orders passed by this court and also the arbitration clause, whether it is applicable in this case or not. Because, my lord, I have filed the suit after obtaining leave from the order of the liberty granted by this honorable court, my lord.
You can filing of a suit is not barred. Parties may waive their rights to go before the arbitrator. So it's not that the suit is barred. You can. Both the parties may also agree. Yes, we will not go to the arbitration. We will proceed with the
My
suit.
lord,
So even by going that this court gave you liberty to file a suit,
your lordship
that
kindly-
does not take away a right under section
my lord,
18,
after-
8 to refer
my lord,
these
after
parties to
getting
arbitration.
after getting summons, after 1 year,
Language says prior to filing of the first statement of defense.
Yes,
That's
my
the
lord,
express
my lord,
language.
that will be
And
evident,
this
my lord. Your
judgment
lordship-
of the
my lord,
division
your
bench
lordship, kindly allow me-
is distinguishable
my lord, your
on
lordship, kindly
facts.
allow me to place the orders passed by this court, my lord, passed by the learned court, my lord, one after another. Order number 2 dated 24/3/2025.
So please show me the arbitration clause. You are saying that the arbitration clause
Yes.
is void. Please show me that first.
Page 60, my lord,
1660.
60 plus paragraph 80.
What is the nature of the agreement?
My lord, that is mortgage loan, my lord. The loan has already been liquidated.
Arbitration,
My lord,
yes.
it will be evident from the order passed by this court, my lord, in this petition. My lord, that will be evident, my lord. What are the
Yes, arbitration is clause 18, yes.
yes,
Why it's void?
yes, my lord. For all dispute differences and a claim arising out of these presents, including any dispute as to the amount outstanding or in any way touching or concerning the same or as to the construction, meaning and effect thereof, as to the rights and liabilities of the parties hereof shall be settled by the arbitration to be held in accordance with the provisions of the Arbitration and Conciliation Act or any statutory amendments therefore and shall be referred to the arbitration of a sole arbitrator to be nominated by the capital first, my lord, that is a defendant. My lord, that is a defendant, my lord, that is barred under section 12. Mother 12 is specific, my lord, they cannot nominate my lord arbitrator. Neither of the parties can nominate the arbitrator. It is there, my lord, then in the event the death, refusal, neglect or liability, incapability of a person so appointed to act as the arbitrator, capital first may appoint new arbitrator. My lord, they are the defendant. My lord, they cannot appoint arbitrator, my lord, that is barred under section 12.
Why did you agree to this agreement? Why did you agree to this agreement?
Even if a-
What is the suit for?
My suit is for damage. My lord,
For?
suit is for damage, my lord.
No, damage for what?
Well, damage for loss of valuable documents and for harassment and for and other things, my lord. If your lordship kindly see the order passed by this court.
Yes.
May I place, my lord, the order passed by this court, my lord?
Yes.
That is, my lord, annexure A, page 17.
Yeah.
Court, my lord, can take liberty to file the suit.
No, that is neither here nor there. You can file a suit.
My
But
lord,
that
page
by itself
15, my
cannot
lord.
take away the right under section 8, Mr. Gupta. Filing of the suit, I've told you,
That
both
is
the
true, my
parties
lord.
can
Suppose
agree.
whether they have submitted to the jurisdiction by filing a petition, they will contest the suit. Costs have been imposed for recalling of the ex parte order, That is the order of
They
the court.
contested the suit.
My lord, suit has not commenced, my lord. Well, suit has not.
So,
My lord, they filed an application that they want to. My lord, your lordship, kindly see, I'm placing one order before your lordship. Your lordship, can allow me to place one order.
yes.
Well, just a minute. My lord, the order dated, order number 6 dated 18/12/2025. Parties have taken their respective steps. Today is a date fixed for hearing of the petition dated 30/6/2025. My lord, that is.
Page.
My lord, that is a certified copy of it.
Certificate copy. Which order? Which order?
My lord, order number 6 dated 18/12/2025.
Yes. Yes.
Having regards to the submissions made by both sides, the petition dated is allowed at the cost of rupees 2,000. It is their petition. However, the order dated filing suit for ex parte hearing stand recall. The plaintiff is directed to serve copies of the documents which were annexed to the plaint for payment of the cost and further reliefs.
What is the effect of this order?
My lord, there is an order that they want to contest the suit, my lord. My lord, order number 3 dated 30/6/2025. Today is the date fixed for ex parte hearing of the suit. Plaintiff files Hajira. Defendant files 2 petitions praying for allowing the defendant to contest the suit. My lord, this is a submission to the jurisdiction of the court.
Please show me the application. Applications which were filed.
This is the observation of the learned court.
Please show me the application. If the application states something, court records a different thing. Can by the recording, the court can be bound by that. Please show me the application for recalling of that ex parte order.
Application is not with me right now, my lord. This is observation of the court.
Please bring the application because
Another, my lord, whether the alleged agreement of the arbitration is here under section 12. It is under
show me section 12 how it is
Yes.
void.
Yes.
Yes.
Section 12, let me see. Grounds for challenge. Well, these are grounds for challenge. When a person is approached.
So you have to challenge that. You have to challenge that. Appointment, if
Well,
it is
that
made,
stage has not come, my lord. Well, that
so
stage has
if it
not.
is an appointment is made, on the basis of that, you can challenge that. Then the court, Mr. Gupta, there are two ways of looking at it. Arbitration Act provides for a separate recourse. Now, there is a provision for appointment agreement. So when there is an arbitration agreement, so it takes out of the jurisdiction of the court, parties can apply, say, yes, let this, the subject matter falls within the arbitration agreement. So section 8 can be filed. Now, after the section 8 is filed, now the question of appointment comes. So appointment, the parties may agree. If the parties do not agree, section 11, there is also a procedure. Now, if an appointment is made on that, you can challenge that. Section 12 says that.
My lord,
So that stage has not yet reached.
no, that stage has not yet.
So this is only a reference, might be a different, but that cannot be a ground to say, no, I can proceed with the suit. It may be, yes, the court may say, yes, not that arbitrator in the section 11, an independent arbitrator may be appointed. But for that, it cannot be a ground to proceed with the suit. Rejection of section 8 cannot be at that ground. If you have authorities, you can place that.
There are authorities, I think. So, my lord, there are authorities, I think. So, my
On
lord,
that ground, section 8 can be
so, my lord,
dismissed.
that is not, my lord.
I'm on that.
The arbitrator
I'm
of their
telling-
own, my lord.
That's the different, I'm telling you, that will be the subsequent stage. When it is relegated to the arbitration, then who will be appointed, whether Mr. X or Mr. Y, that's a different chapter altogether. Question is whether it is to be tried by the civil court or through arbitration proceedings. That's the object of this act.
My lord, your lordship kindly consider, as per order of this honorable court, my lord, I have filed this suit, my lord. If your lordship kindly see the order of the honorable court, my lord,
Please
these
show me.
disputes,
Please show me.
disputes in the suit, my lord, cannot cover the arbitration clause.
That's the specific observation of the High Court.
No, my lord, that is not the, what are the,
So,
what
so
I,
you are saying,
no, my lord, I am not on that, my lord. I am not the observation of the.
please show me what is the observation for which it cannot be referred to under section 8. Please show me that.
That is not the ground. That has not been stated by the High Court.
Then,
What, my lord,
according to you, pursuant to a leave granted by the High Court, you have filed a suit. Accepting that, no difficulty. But the question is whether mere by granting liberty, it takes away the statutory right under section 18 of a party.
not that the dispute which has, my dispute is not covered by the arbitration clause, my lord. That is my submission. Dispute which has been granted, liberty which
Why?
has been. Liberty which has been granted by this honorable court for filing a suit, that dispute is not covered by the arbitration clause.
Please show me that. What was the dispute which was referred to be decided by way of a filing of the suit, and it is not covered by the agreement? Please show me that.
My lord, may I place the order? Place the order of the High Court.
Or if you want to come back with the application for ex parte hearing, you can come back with that also, because that might also be relevant. Because if you cannot succeed on this, then you have to harp upon that you wanted to contest. Please bring that copy of the application.
I cannot follow your lordship, my lord. I cannot follow you.
Ex parte hearing, the suit was fixed for ex parte hearing. Then that was
It was recalled, my lord.
yes. So please bring that application, because you are harping on the finding of the learned trial judge that the court recorded that they filed an application to contest the suit. I want to see the prayers in that application.
For filing written statement, that is the context for filing written
Please bring that application. Please bring that application.
statement. Next week, your lordship.
after some argument, Mr.
Malad, he's saying, Malad, there is possible determination, Malad, that is, Malad, I am not on the, I want to do the matter before your lordship. If I win or loss, that doesn't matter, my lord.
Yes, yes. Mr. Mukherjee has ready-made informations.
Your Lordship, this is a
Yes.
matter with regards to a partition suit. This partition suit is still pending for almost 8 years, Your Lordship.
This is the only partition suit which is pending
Yes,
for
Your
8
Lordship.
years.
Apart from that, the
All
respondent.
partition suits disposed of.
No, Your Lordship, the partition suit is still pending. And apart from that, Your Lordship, the respondent authorities have
What is the stage of the suit for partition?
the parties are making so cause. They have filed.
Cause.
Yes, Your Lordship. The
So cause upon whom?
so cause upon the petitioners of that respondent. In that.
Please show me that order. Where is the order sheet?
Yes, Lordship.
So cause as to why the temporary injunction shall not be granted.
Yes, Your Lordship.
This is an order of 2018. What happened after that?
After that, Your Lordship, that they are filing hajiras, appearances, but none of this matter parties were appearing and proceeding with this matter. Apart from that, Your Lordship, they have appeared before the LRTT also. There is a multiple of suits with regards to this petition, Your Lordship. My humble prayer is before Your Lordship. Kindly grant us this prayer that these petitioners were were in the age of 60s. All were at 60s. Kindly grant us so that this matter will comes to a conclusive end before this senior division.
What is the next date fixed for hearing of the injunction application?
December, Your Lordship. 11 December, probably.
11 December has long, 8th of December. That has long expired. In 2026, what is the next date fixed? Now we are in
11 December. 11 December, Your Lordship.
2026.
2026. This matter is with regards to a identity of an opposite party, with regards to Abdul Udud.
This application.
There are two suits. One is filed by the petitioners and the other is filed by the opposite parties. My DAG number is, in respect of my suit property, 207 and 208. And the opposite party's DAG number is 212 and 213. What happened, my lord, in my suit, the opposite parties has filed an application under Order 26, Rule 9, praying for commission appointment, and which the learned court has allowed, incorporating the schedule of both these properties. Their properties, including myself. But my plaint is in respect of 207 and 208. And the learned court allowed even inclusion of 20212 and 2. You can see the improved order. How can it be?
There is no boundary dispute.
No boundary, my property is completely bounded with
By boundary walls.
boundary walls. Yes,
What is the suit for?
good for declaration and permanent injunction. They are
Permanent injunction for what?
since we are starting construction after obtaining the sanction plan, the opposite parties, they are objecting to that. They are saying that we are encroaching their land. Can you see the impute order?
Local investigation is the best option. If there is a boundary dispute, these two plots are adjacent. These two plots are not adjacent. How can the encroachment occur if these two plots are not adjacent property?
In my suit,
Your property is 207 and 208. And what is the property of the defendants? That's not adjacent. If that's not adjacent, the question of encroachment does not come. Your cause of action for permanent injunction goes then. That is what I am asking you. If it is not, sir, can an encroachment be made on a property which is not adjoining?
Super, their DAG number is different, but my DAG number is
Sir, I have followed. I am asking you adjacent plots. I am not different plots, but adjacent. Unless the plots are adjacent, there can the question of encroachment come.
their case is that, and their case,
So,
their case
so
also
now-
that we are making unauthorized.
So now the question of boundary dispute. You may have erected pillars, but if that has gone into the adjacent plot,
Really consider this, but my, their property should not be inspected. My property should be, and the points what the landed court has allowed, let's kindly see.
yes.
Survey first commissioner shall conduct local investigation on the following points. Identity of citizen and citizen. With the plaintiff.
Where is the application under order 2609?
That is at page 45.
Yes, what do you say? That this dispute, boundary dispute, do not fall within the expression elucidating any matter in dispute. Does it not come within that?
I'm not saying that. My
Then
only point is this.
You are saying that
They are trying to incorporate their property in my suit
has to be, if that is the dispute.
without amending my.
Sir,
claim.
I'm asking you, boundary dispute can be decided by way of a local investigation. If there's a boundary dispute between two plots,
He can go and inspect and file a report.
I'm not going to these facts. I'm taking a hypothetical example. There's a boundary dispute between two parties. Can a local investigation be held or not?
Can be done.
How? Why? Boundary dispute, that has to be between two plots. So if the other plot is not investigated, can the dispute be resolved?
True, my lord.
Then it says matter in dispute. It does not say that particular plot. Then this type of disputes cannot be decided with regard to one plot.
Alas, give them notice, my lordship. I pray for 16th is the day fixed for inspection, my lord. Also, my lord. August.
Where is the written statement?
Their written statement,
Yes.
page 27.
Yes, kindly come to page 29, paragraph 16 of the written statement.
Page 29, paragraph 16, yes.
Yes.
Defendant state that the lands of the defendants being RS number such and such are adjacent to RS number such and such. That is true.
And then, which the plaintiffs partly encroached.
But that is their allegation. That is their
How this can be decided?
allegation.
On the basis of allegation, this will be done. You will allege they have encroached, you will file an application under order 26/9.
But in their suit, we have also filed our. Kindly consider this.
The learned But I am appearing for the opposite party.
Yesterday, kindly remember I moved the matter. That the matter was
Yesterday you moved this matter.
this is connected. Why I'm telling your lordship? Now, my lord, I filed an application for grant of probate. Now, my lord, in that application, my lord, that my lord, when citation has been issued, one lady appeared and he want to file objection. Ultimately, that lady died. Now, my lord, then some of her legal heirs filed an application to impede the same. I filed an application under Order 22 Rule 4 Sub-Rule 5. The court allowed my application. And in the bottom portion written, take steps. I was under the impression that Order 22 Rule 4 Sub-Rule 5 means I'm not been directed to file any application or not to bring the record of the legal heirs. Next day, ultimately, court said you have not complied order. My probate suit has been dismissed for default. Dismissed for default. I filed an application 151 for recalling, showing that this is not right because you have allowed my application under 22 Rule 4 Sub-Rule 5. Court is not giving any date. That's why I moved before your lordship court. Your lordship directed to immediately file a put-up petition. And if I file a put-up petition, court will hear the application in accordance with law. Now what happened, my lord? My learned senior friend's client, filed a suit for eviction against my client. I entered appearance. I filed written statement. In the written statement, it has been categorically mentioned that before the death of the person, he executed a will and that the subject matter of challenge is probate proceeding. Then I filed an application under Section 10. Court rejected my Section 10 application under Section 10 of the Code of Civil Procedure that you may, ultimately he may proceed with the suit, but no final degree shall be passed. But what the court has done, court said your application for probate proceeding has been dismissed for default. Therefore, you cannot maintain this Section 10. Now, I point.
Which one is earlier? Probate is earlier.
Probate earlier.
No, the suit, the eviction suit is
Possibly,
earlier.
my lord, possibly subject to correction. And my lord, kindly see once the impugned order.
Eviction.
No, which one is earlier?
12, eviction suit.
That 2008.
2018 and the probate
Probate proceeding is 19.
yes. So it is a
I received the summons. I don't know about the suit.
in the written statement, there is a counter
Order has been passed by the special official building of the KMC regarding unauthorized construction. Being agreed with the order, I prefer an appeal to the building tribunal. That is the appropriate forum. In the meantime, they have an office order of 20. Kindly come to the page 68.
Page 68. Yes.
The office order has been issued by the Director General Building regarding unauthorized construction of a Bostibari Thika. Come to the subject matter first.
Yes.
May I read minute? Guideline for sanctioning of building plan and regulation and calculation fees of the charges for unauthorized construction of the small plots under refugee rehabilitation scheme, land of government and Thika property and Basti area. Just for specialist category. And that is passed by the MIC and next page 69, DG building has signed. On the basis of that office order, we made an appeal to the Thika controller of Thika tenancy. Page 42, kindly come to the
42.
42.
Yes.
On the basis of our application, kindly come to the page 74.
74.
We have paid for regulation and NOC from the Thika. Deputy Controller Thika tenancy. Kindly come to page 74, subject and reference. These two is vital.
So spot verification, then
Subject prayer for regulation on the basis of that prayer. Spot
Yes.
verification is but done and matter is pending before BT appeal. In the meantime, SIR come, election come, though they told my petitioner will do after the election. In the meantime, one PIL has been referred by some Muhammad Isamuddin and page 77, can come to the page 77.
yes.
We are not made in the party in this PIL. Contractor has made party. I ran to the BT and asked for a stay petition. I moved the stay petition. The matter is pending before learned chairman of BT tribunal. Give me a stay, at least dispose of the matter. At least Thika controller refused or allowed me, whatever may be. But come to the, but I have been refused. My stay petition rejected by the building tribunal. Whereas matter pending before BT, appeal is pending there, and my prayer is also pending with the controller of Thika tenancy on the basis of the office.
So your premises also included in that public interest litigation?
Yes, my lord. And corporation on that PIL, corporation on that PIL in the writ petition, the petition of the PIL, corporation never said the entire story behind my back. Corporation never told the story that BT appeal is pending, Thika appeal is pending. Kindly come to the page 78, whereas they declared that property is a work.
No, after this, what can be done? The division bench has directed, what can be done?
Not
Yes.
Mirror in that PIL, story has suppressed. That my BT
You have to take out an application for recalling of the division bench order. Division bench directed this. After that, nothing remains. How can the building tribunal also pass any orders on this?
My appeal pending before tribunal as per office order of the corporation.
No,
we have
here
prepared
has written instructions, the executive instruction, upon the construction which was as per the, your property is which? A, B or C? Which one?
C.
Yours is C. For the purpose of effecting, so far as A and B concerned, such and such. Directed to disconnect C for the purpose of effecting the demolition in respect of the is entitled to C. is unauthorized and department has demolished, and the next date of demolition is such and such. Adequate police help. So division bench has directed implementation of this order. How can that be stopped?
You know, they have never made any.
I follow that. But can that be modified by this building tribunal or by the single bench?
Next date of the PR
If
is 28.
it could have been if the division bench directed to consider to take a decision, after that any decision has been passed, it's one thing. But here, after considering everything, the Honorable Division Bench has directed execution of that demolition.
But you have not made the party.
Sir, where from here I can, how can I disregard the order of the Honorable Division Bench?
The BT appeal is infectious, my prayer is infectious.
Has to be, because the BT appeal also cannot go beyond the order of the Honorable Division Bench. Nothing remains to be decided. I do not know why that was kept pending. Stay application rejected, appeal pending. What remains in that, Mr. Mukherjee? Stay application rejected, appeal pending.
Nothing remains. It is
Yes.
not, my lord. Nothing remains.
Let him show one building plan. If your lordship kindly see,
That's neither here nor there. Stay application rejected, appeal pending.
but
What remains? What you will do with the appeal?
now, my lord, if your lordship see once the impugned order, your lordship will find after demolition again construction made. This is a specific.
But
Kindly see, if today this is a ploy to avoid the implementation of the order of the Honorable Division Bench in the PIL matter. He knows the order, because kindly see that while deciding the appeal, Municipal Building Tribunal has considered the judgment of the Division Bench. He knows that fact because in the appeal,
No,
he
madam,
has, kindly,
I have got a notice from the
kindly see,
KMC.
my lord, once the impugned order,
where
Notice
is
from
that?
the KMC.
Impugned order of the Building Tribunal.
Yes, yes. Where is that? No. I've got that.
May I
Where
just,
is that division bench?
may I just,
Yes, yes.
it has been recorded.
Prefer WPOP 1 of
That's
2025.
the public interest litigation. Then second thing, if you lordship see once, there is a suppression in one, and he is saying the owner in one that I will not go on that. Now it is a ploy to not to implement the order of the division bench passed in the public interest litigation. If he wants to say something, he may apply before the division bench. Look here, I am not a party in the proceeding. My building
You're
is
not a
demolished.
party and order has been passed before the division
Application
bench. You have
before
to
that court.
I wait today. Matter. I
division
went
bench.
Matter
Then
is
what
fixed
happened?
today. Matter has been fixed today.
Today,
I went and
what I can do, I can adjourn it. I can keep it in the next week.
He will show before. No,
I have been,
this will
I
not prevent
directly
an order
made a
of stay, because what happened?
No, it is expected to taken up today.
Already.
already taken, man.
What happened? Yes, what happened? Taken up, then what happened?
Next day on the report has been called for, and 28 is the next date, and I have been asked to made appeal before division bench.
This become infructuous because division may given liberty.
Application of the addition of party.
No, in the division bench, what proceeding is there before the division bench?
A public interest litigation has been filed saying that
Again, no, that was.
this is pending. This is pending.
Oh, this is pending.
Pending. As we have not demolished the portion, there are certain observation today by the Honorable Division Bench. Then my learned even approach before that court. He has been given liberty verbally. You may file application. Now this revision are subject to correction by Lordship become infructuous.
What remains? Or this can be directed to take.
This cannot be, because he has already been filed. You advised to file application.
Monday I will file definitely.
Oh, দুটো হবে তোমার ওখানে আরেকটা হবে, এটা তুলে নাও, তুই ওখানে করবে আবার।
Today's order.
I mean directed to verbal directed to.
All right. So since you have not been made a party, you have taken steps there. You have mentioned that matter. In that matter, you appeared.
Interfered.
And what order has been passed there?
As we have not completely demolished, some strict observation has been made. Police was further directed. I will different the learned additional advocate general, they are appearing, but therefore I cannot say anything. But this is the stand. We have to comply, because when he approached that court, and the verbal observation of the Honorable Acting Chief Justice, you may apply. Therefore, my lord, my respectful submission that parallel proceeding should not be, my lord. He ought to, when he have already mentioned the matter, therefore he can take steps in accordance with law.
I think it's better if I pass any orders here, then it will be difficult. What do you want now?
Withdraw করে নিয়ে ওখানে করবেন।
No, I cannot say that. Either I have to record, or if you want to withdraw, it's up to you to take
If your
steps.
lordship adjourn the matter, he will show to the officers, then it will be a conflict of judgment.
Not adjournment, either I will pass an order, or if you withdraw, I will record that. Because since
I withdraw the matter. With
Uh,
liberty.
yes.
Already
Somebody will come from.
But now the division bench has passed an order.
I put a question myself.
Building tribunal also cannot bypass that. Maybe I follow that you are not a party, but what can be done?
Mr. Mukherjee করে ফেলেছে। ওর নামটা বল।
Neither I nor the building tribunal can say that this order should not be followed.
He is Mr. Gupta, not Mukherjee.
No, I've said Mr. Mukherjee is. I've recorded Mr. Mukherjee. ওনার নাম তো Mr.
Your lordship will find.
Yes, next. Yes.
Okay, for the petitioner method. The petitioner is a defendant in a suit for partition, my lord. In the said suit, my lord, preliminary decree was passed. After preliminary decree, my lord, surveyor commissioner was appointed, who has initiated the work and finally submitted a report. We have filed an objection against that report, my lord. Thereafter, examination of the survey commissioner started, my lord. After completion of my cross-examination, my lord, the plaintiff's cross-examination started. Then time, I obtained a certified copy of the depositions of the survey commissioner, where I found that certain question I have missed, my lord. I immediately filed an application for recalling of the survey commissioner, my lord. In the meantime, also, my lord, certain development also took place, my lord, that some of the defendants who were in the suit, my lord, had transferred their property to a third party, my lord.
That's a different.
May I, my lord? Subsequent to which a status quo order was passed, my lord. We are not wanted to them party in the proceeding, my lord, but we filed an application for recording so that our shares could not be affected during the time, my lord. All applications, my lord, the recalling application for the survey commissioner as well as were taken up for hearing and was turned down by the learned court, my lord.
No, the application commissioner's report, the petition for recent order against the commissioner's report, petition for cross-examination, and the petition for cross-examination of the petitioner all filed. So these are only with regard to cross-examination.
Yes, of the survey commissioner.
Yes. Only that was rejected.
That was rejected, as well as my application for bringing of the record, that was also rejected.
No, that is neither here nor there. Please see the ordering part.
If my lord kindly sees.
Only for first the cross-examination of the learned commissioner by the plaintiff, the date was fixed. What happened thereafter?
Thereafter, my lord, date is been fixed.
So no, it's only the application for recalling.
Yes.
So nothing, not other things. That has only been rejected by the. Be passed without the leave of the court. Paragraph Yes, next. Yes.
We are the document daters, Lordship, kindly come page 23. This is a title execution.
Who is for the caveator? Caveator soft.
Lordship, kindly see, perhaps my instruction, okay, notice of caveator.
What is the order of order? What is the date of the order?
Lordship, kindly come page 23.
What is the date of the order?
Lordship, we have certified copy.
Yes, please check up. Dekhan to na. The next.
New motion, Lordship, that because.
Yes, next.
Lordship, item number 22 was filed by your Lordship's leave to move the matter today. Lordship, the crux of the urgency is that, Lordship, the petitioner plaintiff filed one title suit with a prayer for partition and permanent injunction. And Lordship, the defendant opposite party filed the caveat. Due to that very reason, Lordship, the petitioner plaintiff served the copy upon the defendant opposite party. Thereafter, Lordship, a long date was given for injunction hearing. Due to that reason, Lordship, by encashing it, the illegal construction is going on over my plot, Lordship. The illegal construction was going on. And Lordship, I candidly and honestly, I am placing before your Lordship one submission that, Lordship, I preferred one application for shipwreck, that means for preponement, by giving the put up petition. Firstly, the date was preponed. That is the name of the learned trial court was pleased to fix the date from 21/9 to 11/8. But Lordship, 11/8 also too much long date, and that's why again I preferred another put up petition to preponement.
11/8 is too much long.
Lordship, 11/8 is why 11/8 is too much long, Lordship. Today is today is 7/8, but 11 is why too much long? Because on 11/8, if the defendant opposite party will not file the written objection, then again
I cannot pass orders on apprehension. Asan.
appear for the petitioner, but led by Mr. Aniruddha Chatterjee, who's appearing online.
Yes.
But I'm led by Mr. Joydeep Kamping. So short passover. Since
Short passover.
But there's a problem. I'll tell you, Lordship, but why I'm saying, Milord, I'll take 5 minutes, so by
2
that
p.m. Mr. Chatterjee, Mr. Kaur is opposing you. 2 p.m.
may I say this? I may start, Milord. By that time, Mr. Kaur will come. This will take a little bit of time.
So it's better because now you are hungry, Mr. Chatterjee. It's 1.
I'm not, Milord. I'm very.
Instead of 2.
So 2 p.m.
Kindly see that because Mr. Kaur has a fixed matter before the court 37.
But I have a problem.
Then what can be done?
3:30, my lord.
3:30. I will.
30 today.
3:20.
3:20.
3:20. 3:20, my lord.
3 o'clock. My lord has a matter fix of mine, my lord, at 3 o'clock.
My lord, Mr. Kaur has a fixed matter, my lord.
I have a
2 p.m. 2 p.m. I can fix. You have to make arrangements. 2 p.m. Yes, next.
That kindly keeps it on Monday, my lord.
I have no problems, my lord. Let them give an undertaking that they will not take my possession.
My lord, there is only.
Yes, next. Call the next matter.
Lord, may I come back at 2, my lord, then?
Yes, come back at 2.
Very good.
Please, your lordship, I appear for the petitioner.
Yes.
Mukherjee. Now, my lord, the immediate urgency is, what prompts me to come to your lordship. There's an order passed in a insolvency proceedings,
How much time it will take? Can it be taken up on Monday?
No. It will not take beyond 2 minutes. Beyond.
I have a leader, Miraj. I was only humbly beseeching if it can be taken up on Monday, subject to Miraj.
No, I have no problems.
1 second, let me
I have no problems.
at the first sitting of the court, subject to my lord's convenience, I have a leader, Miraj, in Mr. Jishnu Chaudhary, senior advocate. He is not available today.
Only this.
First half
What
on
will
Monday.
happen if it is taken up on Monday?
Monday, the matter is fixed before the NCLT, the content matter.
At 2:30 p.m.
Now, my lord, the only thing is what prompts me to come to your lordship. From the order, the contempt of which is alleged, my lord, we have carried an appeal before the NCLAT. The prima facie, my lord, the NCLAT has.
No.
Yes. That is not correct.
Sir.
Their demurrer is fixed for hearing on Monday. They have filed a demurrer.
They are on
The NCLAT has refused any stay.
NCLAT, what happened? So there is no caveat.
There is no caveat, Miraj. I have seen the causeless.
Then, Mr. Bhattacharya, it's better you give them copy. I'm taking it up on Monday.
Only this much, my lord. I am only requesting your lordship. I will give them copies. I'll serve everything. My lord, on Monday, my lord, let it be recorded that we will be praying for an appropriate adjournment till such time the matter is heard by your lordship.
But if your lordship,
Because my lord, kindly
May I
visualize.
just indicate
Mr.
one
Sen, only
thing?
one thing. If prior to that he is challenging
May I just
something,
indicate one
if
thing?
prior
asking the lordship to see.
But he knows the matter then. He knows. Let him proceed. Let him proceed. My lord, we'll proceed.
The demurrer application has been fixed for hearing. His demurrer application.
so he says the contempt application is fixed.
No,
for-
my lord, the demurrer application is not being taken up. That is our.
It is his demurrer that will be heard.
His demurrer will be taken up for hearing.
Not the contempt.
Thereafter.
Thereafter, Mr. Bhattacharya,
Please see page
so
235.
thereafter on that date.
If at all it is permissible. If at all.
Miraj, may I only request, Miraj, if it beseeches my lord, kindly keep this matter Monday in the morning.
Give them copies. I'm keeping it on.
I will. Monday the matter is fixed before the NCLT. My lord, NCLAT was approached. NCLAT is unable to take up the matter, my lord, owing to paucity of time.
The NCLAT has refused the stay, my lords.
He is not even on caveat. He is making submissions. My lord, this is
Because
the
incorrect
compilation
statements
of
have been
all
made.
orders.
Incorrect facts
What
have
is
been
the
stated.
impugned order? What is the impugned order?
My lord, kindly see.
Kindly see paragraph 4 of that impugned
Not
order.
page impugned order.
Page.
I'll just give you.
401.
401. Annexure J, volume 3.
First one is the contempt, then his demurrer. Demurrer is considered.
But he is not.
401, yes.
Yes. My lord, kindly sees.
The first one,
My lord,
the number that is
on the
contempt.
other hand, my lord, I'll just skip over. My lord, kindly sees paragraph 4.
Yes.
Or rather, my lord, from paragraph 3, we observe that aforesaid two IAs have been at 404.
404.
404, yes.
We observe that the aforesaid two IAs have been filed against the erstwhile RP on the grounds the erstwhile resolution professional has no locus standi to file the contempt application or the execution application. Milord, this is the demurrer.
Now, why this? Yes.
There is a reason. Now, Milord, this bench
So
observe.
this is by you.
Yes.
These applications are by you.
No, these applications are by me, I admit it.
Yes.
This
Pending
bench,
adjudication.
Yes.
True.
Yes.
This bench observed, this bench observed that the respondent has filed the demurrer petition as well as the reply to the contempt petitions and have challenged the maintainability of the contempt petitions in its reply filed in the main petition and demurrer for dismissal on the same ground of maintainability. Therefore, the bench granted option to the respondents to withdraw the interlocutory applications filed on maintainability in terms of this. However, the respondent is not ready to withdraw any of the IAs, that is this. Rather, in response, the learned counsel for the respondents referred to paragraph 4 of the previous order of this adjudicating authority dated 16th April and submitted that IA number such and such and IA being the demurrer applicants were filed on 16/2 filed being before filing the reply on 31/1/2016. Thus, the council reiterated that the reply is filed pursuant to the direction of this adjudicating authority contained in the order dated this, were directed to be listed along with the contempt petitions. The counsel for the respondents thus contended the demurrer petition which is filed prior to the reply needs to be heard on merits and to be decided first, and the contempt petition may be heard and decided post hearing the demurrer application. And
yes.
16th.
So first the demurrer application. Yes, Mr. Mukherjee.
Milord, that was our prayer. They are not even willing to hear, Milord, the demurrer. Milord, 16th April, Milord, that was, Milord, the observation. You come back with instructions, and now, Milord, we won't hear it. You can raise that point. Now, Milord, I'll give your lordship, Milord, just two very important facts.
Only one thing. Who is Mr. Sen? You are opposing or Mr. Shah?
I am opposing, Milord.
Yes.
Milord,
But,
I was
what,
appearing in the
when-
tribunal.
when
They are not willing to
when
hear
a
the
demurrer
demurrer.
application has been filed, that has to be taken up fast.
Absolutely, Milord. Let the
that
honorable
be taken
tribunal
up
take it
fast.
up. Let the honorable tribunal take it up.
Milord, I want to indicate something very serious. Milord, I would request your lordships, Milord, to have access to Milord, live streaming to see what's happening in these tribunals. Milord, it's a complete disaster. I'm sorry to say this.
That
Milord.
is for all
It
matters,
is-
not this.
Correct, for every matter. But Milord,
So Mukherjee is saying that in general, not anything particular to this matter.
the lordships, Milord, to have, Milord, can we have a look, Milord, at the parent order here? Milord, my clients, Milord, work,
Only
Milord.
one thing, Mr. Mukherjee, they want, because they are not on caveat. But since all the parties are there, can you serve? I can take it up on Monday.
Yes, but in the meantime, Milord,
Because
Milord, the matter is fixed on Monday, Milord, both parties should pay for an adjournment.
Milord, Monday morning, Milord, if subject to Milord's convenience, if it can be taken
morning,
up.
it's difficult. I'm keeping it. Monday, they will be paying for an adjournment. Please don't oppose. I'm fixing this on Monday.
Milord,
Otherwise, this will become infructuous.
And Milord, we
Milord,
shall
may I?
have-
Make this infructuous.
Milord, if the demurrer can be heard, it is their demurrer application.
Milord, my prayer, Milord, was, Milord,
No, Mr. Mukherjee, do you have any difficulty if the demurrer is taken up and that is allowed?
not on Monday, Milord. That's why I want to show one or two things to your lordship.
Milord,
So can be adjourned on a future date.
if it commences to my lord, can this matter be taken up on some priority on Monday? Milord, so that Milord,
I also have to.
I understand that, Milord. Milord, I'll tell you,
I will be
Milord.
fixing a date.
These
So-
proceedings arise, Milord, from an order which my learned senior friend's client has suffered. They went up in appeal
I
before the
will
Honorable
consider
Appellate
this.
Tribunal.
I direct them to.
They have
keep a
not achieved
copy.
their
On
goal.
that date, they will pay for an adjournment. A short date may be fixed. I am fixing that.
Milord, the tribunal fixes dates, Milord, after 60 days, 2 months. Milord, we do not get a short date.
I will
Milord,
say
kindly
that they
let
will
us
be
take it up. Milord,
requesting
March.
I will be requesting that
This is a
short
special
date may
bench.
be fixed.
Milord, Milord, a special bench is taking up this matter before the tribunal.
That's a problem.
And they are coming from Orissa. They are coming from Orissa.
Milord, it's a
Cuttack.
Calcutta bench.
No.
If you say that,
No, they are not coming
then
from
I have to
Odisha.
consider this passing some orders.
Milord, kindly pass, Milord,
If you say that, because this has to be considered.
Milord, I am not coming the way I am.
That is what I am saying. So they will
Very
pay
well.
for an
Members don't come
adjournment.
from
I will
Odisha.
request the Learned Tribunal to fix an early date. Yes, Mr. Shah, you are.
Milord, the
which
members
side?
don't come from Odisha. That's all that I'm saying.
Mr. Mukherjee.
One member, he is the judicial member of Odisha.
but he sits in Calcutta. I don't know why. The judicial member is my lord, the named judicial member of the Cuttack bench, but he sits in Calcutta.
I'm not here.
Find a matter where Mr. Shah is.
Mr. Mukherjee.
I'm the corporate director. The money is come to me.
Not required to. Members find the contempt and the execution, my lord, my lord.
So you are not a party here.
It should be given a party, but I should be heard.
That's Mr. Mukherjee's choice. He has not implemented you as a party team now. Full stop. Let a copy of the civil. Next. 25.
Matter, I'm led by Mr. Bardhan. I'm led by Mr. Bardhan, my lord. There is a sad demise of the pyramid in this family, my lord. So I'm praying an adjournment on that ground.
What do you want?
And I'm praying an adjournment because there's a demise early in the morning in this family.
On the pair of the learned advocate. Yes, next.
Madam.
Yes. Mr. Mukherjee, can I take up this matter? Baripur Court. Not কি দিলেন? পরেরটা দিয়েছেন। 2328.
I know Baripur, I will not.
From not touch Baripur. That I know.
I don't get any chance to. I am the plaintiff filed a suit for eviction. Now, what is the
statement stands allowed?
I brought my favor judgment, against judgment, everything. Now, kindly turn to the plaintiff. But kindly straightway come to page 8. Straightway come to page 10. But this suit was filed in 2021. Now, kindly see paragraph 2. That the plaintiff states that the defendant approached the plaintiff to allow him to use
Where is the application for amendment?
I'm coming. Before that, I will show 2-3 paragraphs. It is required.
Please show me the amendment application first. Where is that?
At page 35.
Trial commenced.
Evidence started. Your lords, initially defendant appeared, did not file written statement. Then so-called suit was fixed for expert hearing. Then my lord, so-called reply filed allowed with cost. Then again they did not appear. Then again my lord, suit fixed for expert hearing. Then second time cost was imposed 10,000. Now third time when your lordship directed my lord, suit to be disposed of within certain time, this application has been made. This is not a bar, my lord, that the High Court directed early disposal, but I will show from their conduct. First of all, this amendment is barred.
Amendment is barred.
The counterclaim. By amendment, they want to incorporate a counterclaim. Now, my lord, kindly see once, that's why I'm requesting your lordship, if your lordship kindly see once, my lord, the plaint. Plaint, only one paragraph I will show to your lordship. Page 10, paragraph 2.
Paragraph
2. That the
Yes.
plaintiff states that the defendant
Page,
approached page 10.
Yes.
Paragraph 2. That the plaintiff states that the defendant approached the plaintiff to allow him to use the ground floor A scheduled property at premises number such and such, purely under leave and license basis, which is hereinafter referred to suit property. That the plaintiff agreed the proposal and the defendant issued an application for allow him as licensee at the below mentioned property on 26/4/2019 to use it as gym center. Then kindly see paragraph 2. This is for 1 year. Paragraph 3, my lord, that the plaintiff states that it was written on the said application that the license fee shall be 9,000 only, which shall be paid by the defendant month by month within 10 each calendar month. It was also agreed by the defendant that the defendant shall deposit the security money, then only refunded. That the time period kindly mark, my lord, first day of May 19 to 31st March 2020.
Yes.
Now kindly see their written statement. Written statement, my lord, which was filed in 2023 at page 27. Now, my lord, page, I have your lordship got it, my lord. One-year agreement, they did not vacate. Now, my lord, kindly see paragraph 8. What is the stand in the written statement, which was ultimately filed when the court 2 times fixed the matter for expert hearing.
When the suit was filed?
Suit was filed in, my lord, 2021. Because 31st March 2020 was the date. Then thereafter, my lord, they said, give me some time, we will leave. Then, my lord, as they did not, my lord, 31st March 2020, my lord.
Now they want to pay for specific performance of contract.
I'm sorry, but suit was filed in, my lord, in the first week of January 2021. Yes. Now on twofold ground. In the written statement, kindly see what is their stand. Page 28, paragraph 8. Now, my lord, they says that, my lord, that there is a verbal agreement that it will be for 30 years. Very well, no problem. Now, my lord, I will show the conduct from the order sheet. That, my lord, they appeared, they prayed for time 4 times to file written statement, suit fixed for expert hearing. Then they filed application for vacating. That was allowed subject to payment of cost to be 5,000. Then again, subsequent dates, my lord, they choose not to appear. Again, suit fixed for expert hearing. Again, they applied. Now, my lord, that was allowed subject to payment of cost to be 8,000. Now, kindly see, when the evidence of the plaintiff has been closed, yet to be closed last date, they filed this application when, my lord, kindly see the date at page 35. The application was filed on 22nd November 2024. I put this question to myself whether any explanation has been given why this fact has not been brought on record before delivery of their defense. Now, very cleverly, your lordship, kindly see regarding the cause of action paragraph, my lord, kindly turn to that, my lord. My lord, kindly see page 40.
Mr. Mukherjee, on what point you have brought judgment?
On twofold point. Number one, my lord, number one, there is no cause of action. My lord, kindly see page 40.
Another thing,
This is
other
number
judgment?
one. Number 2, limitation point. Why?
Limitation point what? On what? What is
Because
the?
according to them, they want to implement the, kindly see prayer page 41.
Yes, I've seen. Oral agreement of 2019.
No, this is not oral agreement. This is written agreement.
Whatever. That is the prayer, the specific performance of oral agreement. That's their prayer.
Kindly see once, my lord, the agreement date.
2019.
2019. This cannot be oral because this is my.
All right, but they have said oral agreement.
2019. My lord, 3 years.
Oral agreement for lease.
This cannot be because there is a. Very well, that will decide.
Yes.
3 years. Now, my lord, they filed after 4.5 years.
So they have filed this application after the commencement of the.
Evidence is on. My evidence has been yet to be closed, my lord, that juncture. Then third thing, kindly see whether reason has been assigned.
The issue that arises for
appeared before Justice Tandon, same point, same view.
with extreme urgency, my lord, leave may be granted at least to file one, my lord, the revisional application without certified copy, my lord. The most urgent.
Do you have the server copy?
Yes, my lord.
Server copy. What is the urgency, Mr.
My lord, urgency is, my lord, that in the heart of the city in Mirza Ghalib Street, I have property 2 crore and 50 lakhs, my lord, whatever may be, my lord. And my lord, that by the order of the fourth small causes court order, my lord, that the police help has been, my lord, that the directed yesterday, and police cost is to be deposited today. And my lord, that tomorrow, my lord, that the lower court is open, my lord, and most probably means tomorrow they will deposit 20, 30, my lord, whatever amount they will deposit.
File it will appear on Monday.
My lord, it will appear on Monday, my lord. The matter will be taken up, my lord, at any point of time as well.
Let it appear,
on Monday,
yes.
my lord.
Yes. Call the list.
Lord, may it please your lordship, Lord. Lord, Mr. Kaur is there, so I don't think there's a difficulty at all.
Yes.
But I beg to appear, my lord, on behalf of the petitioner, the surface applicant, my lord, challenging an order under section 14. Now, I need to give a little bit of a background. Well, this is a Salt Lake property where I am the 1/3 owner of the property. It's been found, it's an admitted position. What happens is the other defendants, who are my mother and my brother, they have mortgaged the entire property, my lord, and taken loan. Now, the section 14 application, my lord, which the bank files, the order is, my lord, that they will take possession of the entire property. So I've challenged that by way of section 17. The DRT said, no, you can't take possession at all without demarcation of the surface applicant's land. That is modified by the DR80, saying that yes, you can't take possession of 2/3, but 1/3 or anything of my share, but go ahead with the 2/3. Now, which part is mine and which part is the others is not demarcated by anybody. So they have given me notice that they will take possession of 2/3. But which 2/3, my lord? I'm in possession of the entire because I'm the one of the heirs, my lord, of the original lessee. So I'm in possession of the entire, and your lordship knows I have a right over every inch of the property till it is partitioned. This is the matter, my lord, before your lordship. Kindly have a look at page 500.
Mr. Chatterjee, can you restrain the secured creditor from taking the possession of the entirety?
I can, my lord, because I am not a borrower.
Yes.
I am not.
You are not the borrower, and you will restrain the bank secured creditor from taking possession of the entirety.
The entirety I'm not on. I'm on my 1/3.
Yes. So, no, I talked about the entirety.
Sir, I'm on that. That whether if your lordship demarcates, how that demarcation will happen, it's up to my lord, the bank and the people who have my lord, taken money. I haven't taken money, so I can't be thrown out of possession. Kindly have
where is the order of the appellate tribunal?
Kindly first takes up the order of the below the section 14 order 500. I am not on the entire. You can't touch me. That's what I'm trying to say. Kindly see page 500. It says all that, my lord, kindly got that?
The appeal is by the secured creditor.
Appeal is by me.
Appeal before the DRAT?
DRAT by them.
Yes.
By
so
the bank.
DRAT is by the secured creditor.
Yes, my lord.
Yes. Where is the order of the DRT?
Lord, kindly first looks at the order under section 14.
Section 14. Where is that?
500. It is at Lord, volume 4.
What documents you have annexed, Mr. Chatterjee?
Everything, my lord. Whatever is my rights with respect to that property, everything has been annexed, which were all there, my lord, before the DRAT and DRT. But I will not show your lordship the entire, but your lordship should, prima facie, my lord, be satisfied that, lord, my rights in the property.
Yes. Section, page 500.
Page 500.
Yes.
Well, this is the order passed under section 14. I'm not troubling your lordship with the entire. Sees the 4th or the 5th paragraph. The application seeks to take possession of an immovable property due to a loan default. My lord, kindly got it?
Yes.
Default, and it follows the due process as prescribed by the Surface Act, the details of the property at. Well, this is the detail. All the piece and parcel of land measuring be the same and still more or less Sunset, North Salt Lake City extension. within the local limits of Bidhannagar together with the building constructed upon the said land. Then below the plot has been explained. The petitioner granted such and such. Then Milord kindly looks to the ordering portion that the sealed bailiff or court bailiff of this court is hereby appointed as court commissioner to take possession of the following secured assets. And what is the asset? That's the Milord, the schedule of the property. So the entire property, Milord, was directed to be given to the bank.
Yes.
Then, Milord, this was carried to the DRT. Kindly have a look at the order of DRT, which your Lordship will find at the ordering portion. Rather, it starts off, Milord, from 61.
Only 61?
Yes, Milord, only 61. Milord,
And the DR80 order at?
Right at the end, due to
So
extreme
from
urgency-
500 to only 61 to 700.
This is
Pages have been
best,
repeated.
Milord, why, Milord, liquid texts are extremely helpful.
Yes, 61.
61. Milord, your Lordship will see, I'm not troubling your Lordship with the entire. Kindly looks to the finding of the DRT. Kindly turns to, Milord, comes down to 65. I am not on the reasoning. I will come back later if required. 65, allow me to place this. The SARFAESI applicant has 1/3 ownership right in respect of the secured asset. This is a finding, and this finding is also there with the DR80. SARFAESI applicant has made out a prima facie case, and her 1/3 ownership right in respect of the secured asset cannot be taken away by any court of law, including this tribunal. Defendant bank cannot take physical possession of the entire secured asset without demarcation of the portion of the SARFAESI applicant. The purported order dated such and such passed by the learned ACGM for taking physical possession is in respect of the entire scheduled property and as such cannot be sustained. Accordingly, the order operation of the impugned order passed by the learned ACGM Bidhannagar shall be stayed till the next date of hearing. Thus disposed of, IA disposed is also disposed of, fixed 10th of June 2025 for hearing of essay. So, my lord, the impugned order was stayed. This was, my lord, carried in appeal. The original essay, my lord, is still pending against the section 14 order. It is still pending. So this was the interim order granted. Kindly sees this is carried in appeal, my lord, before the, my lord, the DR80, which my lord will find at 612. That's at volume 5.
The order dated 23rd of July.
My lord.
23rd July. Yes.
Kindly looks to the second paragraph at 613.
Mr. Chatterjee, please refer to the internal page because I am looking at the certified copy.
Paragraph 2.
Yes.
Internal page 2. As
Yes.
per meetings of the parties, a securitization application number such and such under section 17 was filed by respondent number 1 Deshna Sarkar, challenging the notice dated 13th of February 2023 under section 13.2 of the Act, possession notice dated such and such under 13.4 of the Act, publication dated such and such, and order dated 3rd of March 2025 passed by the learned additional chief judicial magistrate. This was the order, my lord. Kindly now comes down. The submissions are made, turns to paragraph 10, internal page 5. Submissions, your lordship need not trouble my lord self.
Yes.
This is the argument of the learned counsel for respondent. Again, my lord, the facts are given there. The mutation certificate, everything is given there. Just a cursory glance if your lordship takes up, my lord. And then your lordship kindly comes to the finding.
Yes.
At paragraph 13. This allows me to place it for your lordship's consideration. Some of the facts are undisputed. Undisputedly, one Mohan Sarkar was the lessee of the secure assets who died interstate on 7th of April 2012. It is also not in dispute that the securitization applicant is his daughter, while respondents number 2 and 3, Madhu Chando Sarkar and Moinak Sarkar, are his wife and son respectively. It is also not in dispute that respondent numbers 2 and 3 as borrowers of the appellant bank who have created equitable mortgage by depositing title deeds of the secure assets in favor of the bank. Order passed by the ACJM is challenged on the ground that securitization applicant is one of the legal heirs of Mohan Sarkar, who has 1/3 share in the secured assets, and she is neither borrower nor guarantor of the bank. Mutation of the legal heirs, very important. Of the legal heirs of Mohan Sarkar was carried out in the municipal records, and the mutation certificate was issued on 23rd of December 2019. An undertaking cum indemnity was given by respondent numbers 2 and 3, stating that the said property was originally owned by and possessed by one Sri Mohan Sarkar, son of Sri Atto, and whereas the said Sri Mohan Sarkar had died interstate Atto, leaving behind surviving, kindly marks this, obligers number 2 and 3 hereto as his only legal heirs and successors. This is respondent number 2 and 3 doing it. Then, undertaking given by the respondent number 2 and 3 could not be binding upon the securitization applicant. This is the finding of the court below. Initially, it was the duty of the bank, this is on the bank, to ascertain the legal heirs of the deceased Mohan Sarkar. Necessary legal heir document certificate should have been called for from the competent authorities. Further, very important. Further, when the loan amount was restructured in 2021, at the time mutation order was already in existence, which was issued on 23rd of December 2019. Even at that stage, no steps have been taken by the bank to ascertain the legal heirs of Mohan Sarkar, which was the duty of the bank. Principle of caveat emptor to some extent would be applicable in this case. This is his finding. And he has, my lord, relied upon two decisions, my lord, with respect to which is given in 19. Enormous powers have been assigned to the authorized officer under SARFAESI Act 2002. Bank is the custodian of public money. It is expected from the bank that the loan, my lord, if I am not mistaken, this is probably, my lord, a private bank. It is expected from the bank that the loan should be dispersed strictly in accordance with law. Principle of caveat emptor is applicable to the sale of goods, but the degree of caution which a purchaser is expected to exercise could also be applicable to the bank at the time of disbursing the loan or creation of equitable mortgage. Caveat emptor means let the purchaser beware. Now, this is now he gives below an English decision, then an Indian decision. I'm not troubling your lordship. Now turns to 21. Because he's come to a finding, my lord, in my favor. As has been observed by earlier that the principles of caveat emptor are applicable in the case of sale of goods or for purchaser, but as far as precautions with the purchaser are expected to take similarly applies to the bank at the time when the security interest is being created by a borrower. It was the duty of the bank to ensure as to whether the borrowers were competent to create equitable mortgage in favor of the bank. Mere declaration by the borrower would not be sufficient to satisfy the bank about their competence. Due diligence has to be exercised by the bank. Due diligence means that the bank should take all measures to ensure that its loan account is secured by the mortgage created by the borrower. In the present case, a mere declaration cum indemnity was filed by the son and the wife of Mohan Sarkar that they are the sole owners of the property. Based upon the declaration, loan was sanctioned and equitable mortgage was created in the secure assets. It is established on the material available.
Yes, Mr. Kaur.
Okay. Lord, kindly take section 44 of the Transfer of Property Act.
Appellate Tribunal has affirmed the findings of the tribunal, says it cannot be done. Then how could it modify by saying what's the
Kindly have a look at section 44 of the Transfer of Property Act.
Yes, yes.
It will be, Lord, read to be a mortgage, Lord, restricted to 2/3 of the property.
Yes.
Lord, that is the reason he has modified.
Yes, but how can it's now modification is with regard to the extent of the mortgagors, those
interest in the property.
Interest in the property. Now, section 14 is with regard to taking physical possession.
Now,
so now with this modification, the question is how can you take possession?
Now, Lord, so far as 1/3 share is concerned, for that, Lord, my secured assets can't be put into a fray.
One way, but demarcation has to be done first.
The demarcation part, Lord, today demarcation is not a, Lord, rocket science. Out of the total property, 1/3 has to be set apart. let her choose which part she wants to retain. If she wants to buy out, Lord, let her buy out. There is no difficulty. We are going to collect our dues.
What is the structure of the property?
It's a shop. It's a 3-story building. Lord, having Lord
Equal floor area.
Equal floor area. And Lord, it has a ornament shop. They are running a jewelry shop. Lord,
Yes, Mr. Chatterjee, Mr. Kaur's suggestion, you can choose.
I cannot because below this is Salt Lake property and it is not partible. I cannot.
Mr. Chatterjee, you said yes,
Lord,
cannot be
now I
at
tell
the
you,
entirety.
Now I tell you,
One-third.
no, I understand. I'll give you a logic. This is a conundrum that we are in because of the bank, not because of us. The bank has to take responsibility for this.
Yes,
now, what is the law on
my
partition?
3.5 crores, if they
Now,
return,
what's
I'll release the property.
I have not taken one paisa.
No, Mr. Chatterjee.
I'll give you a logic. One gives me 2 minutes. Now, what happens with respect to the law of partition? My lord knows much better than me. I don't need to make this submission now. My lord, he can very well sell his property. There is no problem on that. He has a right to sell his property. Once he sells and the person who tries to get into possession, my lord, the outsider, I have a right to file a suit for partition and preemption at that
point. File a suit for partition. File a suit for partition.
I will not. Let him sell.
Mr. Chatterjee, without
possession, he can't.
Yes, without because you cannot have the share in the entirety.
No.
So 1/3, if you can choose any one
I
of the
cannot
clause,
choose. But the problem is the law prevents me from choosing. I can choose. He can sell. I have no problems on that. The 2/3 he can sell. But once he comes into Milord, wants to get into Srilekha Mitru, your lordship knows better than me, Milord. Srilekha Ghosh, not Mitru. Ghosh. It's only then I have a right to Milord go into preemption. Till then he can't Milord take possession. Physical possession he cannot take because moment he wants to Milord get into it after the sale, then my right to Milord go to the court comes into play there. So today, Milord, he can't take possession from me because I have a right over every.
Now, Mr. Chatterjee, then this
There
order
can't
has
be
been
partition
modified.
from here.
Mr. Chatterjee, this order has been modified by saying that it stayed to your extent.
Exactly.
So I will not go into that. So you cannot claim the stay over the entirety.
No, the notice kindly
let them take steps, whatever they will.
Now kindly comes
to take steps.
Now sees
the Mr. Chatterjee, for that I gave you. If you want to demarcate your portion that you will be identifying, may not be partition or something, so they can take the other portion.
May I ask
If you
this question?
say that, then
Who
this
demarcates
order
it?
does
May I
not.
ask this question to myself: who demarcates it? This is my respectful submission before your lordship and Milord a query, Milord, who demarcates it? Sees the notice which is given on the basis of which he wants to take Milord possession. Have a look at that.
Yes. It
is right at the end.
Page?
Milord, it's at 623.
623.
Yes. And this is given to not to me. This is not given to me. Kindly have a look at the notice 623. It's given to Milord MC Sarkar and Sons, Madhu Chandra Sarkar, Moinak, and then pasted in the property and says all that piece and parcel of land measuring such and such be same and little more or less.
These two are the borrowers. Madhu
Yes.
Chandra and Moinak
They
are the borrowers.
They are the borrowers. They need their money to sell. After selling the property, they'll get their money. Let them sell the property. Possession they cannot take. Even in a partition suit, Milord, if one of the co-sharer is in possession of the entire property, Milord, it's only by way of a partition suit that they can enter. Not by, Milord, just coming to court and saying demarcate. There needs to be an adjudication on that. And he's told me, give me 2/3 portion. Where? What 2/3 portion, Milord? May I ask this question to myself? I understand Mr. Kaur's.
Then I am setting aside the order of the tribunal also. That says without demarcation, that's not permissible.
Yes, that says.
So that is also to be set aside.
Your
Chatterjee, the tribunal's order also has to be set aside. Also has to be set aside.
May I ask this question to myself? Which order?
Tribunal's order, it says without demarcation. You say it cannot be.
Well,
you have not challenged that order.
No, I need not challenge that order. I am
Yes.
saying,
But
Lord, I am
according to you, this also cannot be done.
Lord, I am
So this order also has to go.
kindly bears with me for a minute. That goes, it doesn't inure to my benefit. What I am trying to say is, my lord, that without there being a definite demarcation with respect to my part, selling, my lord, is a different thing. Let him sell. I have no, I can't have any, my lord, quarrel on that. But selling and possession is different. He sells the 2/3 part. There is no problem on that. I'm not going to stand in the way. He can't sell my 1/3. Once he
Now,
sells,
Mr. Chatterjee, now the issue is not with regard to sell. Issue
It
is
is.
with regard to possession under section
Exactly what
14.
I'm saying, Lord.
That you have
Possession we cannot
challenged.
take.
That you have challenged. You have got a favorable order before the tribunal, which
Understood.
says without demarcation, and
Understood.
you say demarcation is not possible.
Lord,
So
the revision
that
period is
also.
mine. But here, your lordships on the other occasion said that I can't be worse off in my revisional application. So that can't happen. Your lordship knows that well. I know your lordship is putting pressure on me. I can understand that very well.
Not a
But
question of putting pressure, but Mr. Chatterjee,
this is a
you are
question.
happy with that order. You are happy with that order. You did not challenge that
No, they
tribunal's order.
challenged it.
Yes, so that part was in your
That
favor.
order, my lord, is not under challenge in my respectful submission in a way before your lordship.
No, you have not challenged. They
I
have
have
challenged.
not. I have not. Mr. Kindly
Yes.
go to that order. Why I did not challenge? Have a look at it.
Yes.
Have a look at it.
Now, even if Mr. Chatterjee, even if I said that set aside the DRAT's order, let us assume, then this order, let them execute this.
If they want to execute this order, my lord, it's up to them. Kindly have a look at the order once.
Yes.
Defendant bank cannot take physical possession of the entire secured asset without demarcation of the portion. Let them be happy with this order, my lord. I don't have a problem. I'm happy with it.
Yes, Mr.
Kindly have a look at section 44 of the transfer of property.
Yes.
Where one or two or more owners of the immovable property legally competent in that behalf transfers his share of such property or any interest therein. The transferee acquires as to such share or interest, and so far as necessary to give effect to the transfer, the transferor's right to joint possession or the other common or part enjoyment of the property, and to enforce a partition of the same. So, my lord, right to joint possession is also, my lord, inbuilt. The only exception is, if your lordships kindly take the next part, where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family. Nothing in this section shall be deemed to entitle him to joint possession or other.
So according to you, this is not a dwelling house.
Not a dwelling house.
It is. My lord,
It is not a dwelling house. It is a
It is a
jewellery
dwelling
shop.
house. No, no. My lord, it is factually wrong on my learned senior. I'm not saying it's wrong. It is a dwelling house. I can't say.
Ground floor is jewellery shop.
Ground floor.
I stand corrected. The ground floor is jewellery shop, and Lord, the upper two floors, Lord, are supposed to be residential. But so far as the ground floor is concerned, therefore, Lord, there can't be any bar.
There can't be any
bar. So far as my taking possession. Ground floor is concerned, there won't be any bar. The other two floors, Lord, will take action in accordance with law.
Very well. Now, kindly, Lord, that's.
Lord, in fact, I was offering that, Lord, if she takes one of the floors, Lord, we can take possession of the other two floors and, Lord, sell it off. It's an equal dimension floors. There is no difficulty.
After my learned senior friend finishes, I'll kindly turns to Lord.
But that is the reason why I opened up. I said that either let her pay the debts and take away the property. 2/3, Lord, we are prepared to release.
That is the right of preemption.
The preemption right will appear, according to him, the preemption right will come into, will ripen when, Lord, we sell the property. We will sell the property. Let us take possession of the portion which is not, Lord, in not the residential area. That part, there can be a joint possession. There is no difficulty. So let us take possession of that. And, Lord, so far as the other part is concerned, let us sell 2/3. And then, Lord, the partition and whatever the purchaser, let them fight it out with the purchaser. There are 3-story property. It can be equally partitioned. There is no difficulty.
But if the Salt Lake, can it be partitioned?
It can be because
that's the another.
I tell your lordship, it can be because, Lord, now the government is selling. Government is permitting sale on and transfer on certain payment.
Without the permission, it cannot be
No
done.
permission, of course, we will have to take. We will have to take. So, Lord, as of today, it's a matter of Lord enforcing our security, because Lord, they are not paying. They are a defaulter. They have become the account has become NPA. Now, this daughter has been set up because Lord, when the document was executed, the declaration was given by the mother and son that they are the sole owner of the
You have
property.
also not performed your duty. You have also not verified.
No, that there is a married daughter that has not been disclosed by them. Lord, for that, whatever action, criminal actions is necessary, that will be taken by the bank. There will be no, and the main point is that there was no name mutated at that time.
No.
The mutation, Lord, my instructions are that the mutation took place subsequently.
Property remained in the name of, in the records, in the name of the original father.
Original father. And Lord, this is a loan which is transferred by the Axis Bank to us, to Yes Bank. And Lord, post transfer, Lord, a fresh mortgage was created. Lord, when the loan was existing with Axis Bank, Lord, this property was also Lord charged. So Lord, when the loan got transferred to Yes Bank, we took a fresh Lord mortgage of this property. And this at that time the father was not there, the mother and the brother was there. They executed the document. And based on that, Lord, the public money has been distributed.
Factually, probably, Lord, Mr. Cord may have been, Lord, if your Lordship looks to the impugned order once again.
130. Kindly, Lord, come to page 130.
130?
Yes. Volume 1. This is the undertaking cum indemnity, which has been quoted. Your Lordships will find. Please come to page 131. Kindly see, and whereas the Mohan Sarkar had died intestate.
Mohan Sarkar, yes.
Yes. Leaving behind Madhuchanda Sarkar and Moinak Sarkar. Surviving the obligors number 2 and 3 here too, as his only legal heirs and succession. And whereas the obligors 2 and 3 have jointly inherited the said property and propose to mortgage the said property with the lender as a security towards repayment of the said facility being availed by the borrower. And this document has been executed on 30th of November 2019, and mutation is of 23rd December 2019. And Lord, your Lordships will see at 132, there is an undertaking given that they will.
Other heirs are parties here.
Yes.
They are not appearing.
No, they were not served, Lord. There was no caveat.
So let them be served. Let them come before your Lordship.
Yes, they have to be heard, but Mr. Kaur, when are you proposing to take possession?
Lord, according to notice, Lord, we will take possession of the on the 10th, but we can take possession of the jewelry shop. Let the residential house.
On that, it would be problem. So I'm saying that I'm directing them to serve. I'm keeping it in the next week. Where are the parties?
Salt Lake.
According to they're residing in the same property. The mother and son, they're enjoying the property. They are the borrower. And Lord, they have set up the daughter now.
No, I am in possession. I'll show all that. I am in possession.
Mr. Kaur, you will be saying that they have been set up. He will be saying, I do not have relation with them.
There is no relationship. After this, I have taken, Lord, whatever steps I need to.
I know, Mr. Chatterjee, before you opened your mouth, I know your submission will be that.
So
you do not have any relation with
where is the mother and the son? Where is the mother and the son residing? Your Lordship will see from the cause title.
But they may be residing in the same property, but they do not have relation.
Right. So therefore, they must be having separate flats.
Lord, this is not unheard of. My Lord, your Lordship has enough.
No. So I've not said anything to you. I said that would be your submission. I preempted your submission, Mr. Chairman.
Grateful, my Lord. Kindly allows this live streaming to be on when your Lordship is dictating, because they may not switch us off and I can't hear
But,
what.
just two things, Lord, which is coming in my mind. Lord, this loan amount, if they want, Lord, they,
Mr. Kaur, Mr. Chatterjee is saying that I will not pay off this amount.
Lord, I don't
Saying
have
I
it.
cannot, I do not have.
I
So,
don't have it.
so now is one thing is it says with regard to the appellate tribunal's order, it has even if you go by that,
yes,
the question is insofar as it relates to the share of the, you cannot touch that. That's the now it might be difficult. You can advise your client how to take possession. So for that, I'm asking you, I'm staying these proceedings for staying this order for a limited period. I'm keeping this on in the next week any day, either 14th or 17th. I do not know whether the service will be effected within 14th. So I'm keeping that. Let me consider this. Let the
Lord,
other side.
I say that don't stay the order. We will not take possession. Lord,
I record your submission.
Lord, kindly seize the last matter, my Lord, which your Lordship is going to hear at 3 o'clock.
Mr.
It'll
Kaur,
come
it's
up
better
on,
because
Mr.
don't take
Kaur.
on your own
kindly,
shoulders.
kindly, Lord, I am telling your Lordship that insofar as the bank is concerned, bank will not take possession. Record the
Mr. Chatterjee, Mr. Kaur is here.
I have every blood respect, whatever your Lordship.
Sir, when Mr. Kaur, bank officials are here.
He's present. Yes, yes,
He's present. Bank officials are also present here. So I can record also that they are physically present and after taking instructions,
Mr. Kaur has said, Lord, it doesn't lie in my mouth to say anything.
Yes, you are right. At times, the councils are put to embarrassment.
Lordship knows what happened to Mr. Rai Chaudhary, my Lord. I'm sure your
why
Lordship
should
do not
the bank take a course, Lord, which will prejudice their own interests? We are before your Lordship. We want, Lord, the matter to be thrashed out in the presence of the two borrowers. Let them come and say what is their stand. Whether they have set up their daughter or they are, Lord, trying to avoid.
In a way, please consider it can be done in other way also. Because the main proceedings under section 17 is pending before the DRT. I can direct the DRT to dispose of that. I think that's better. Because I cannot dispose of the main proceedings there.
Lord, I tell
Because
you,
this is an interim order, Mr.
No,
Kaur.
true.
Because keeping the main proceedings pending,
but that will impede my right to take possession. Lord, if your Lordship wants, I'm Lord, I've got all the judgments which are in my favor. If it is a residential property, the stand is totally different.
I'm only thinking it allowed if I direct the tribunal to decide that.
Lord,
you can
kindly-
place that. It can be
Kindly decide this as an interim measure whether I can take possession. Lord, residential house, I concede. But so far as the commercial part is concerned,
Mr. Kaur, only what is troubling is the challenges against the section 14 order in section 17 before the tribunal. Main application is pending. This is only against an interim order. It has traveled to the tribunal before this
I tell your Lordship, there is also a view that under section 17, the DRT doesn't have jurisdiction to decide the mortgage, creation of mortgage. Because kindly have a look at section 17.
You can get it dismissed.
Kindly have a look at section 17 of the Surface Act. Lord, the DRT doesn't have jurisdiction, Lord, to decide the creation of mortgage. It is only situations arising out of 13.4. So therefore, Lord, the issue of mortgage, if it is there before your Lordship, kindly decide this. Because, Lord,
can I decide that in a proceeding arising out of section 17? Because the main proceeding is section 17. I can only test whether the tribunal, the orders of the tribunal and the appellate tribunals, the interim orders in effect, whether that was justified or not.
Lord, if your Lordships today send it back to the tribunal,
allowing you to raise all points
with the protection, then Lord, the enforcement of the securities gets prejudiced. Lord, your Lordship.
What is the next date in the tribunal?
I don't know.
Mr. Nayak, if you can.
Because other way around here, then it's tribunal,
it's a legal issue. Kindly, my Lord, test it. Kindly test it. Whether, my Lord, I am entitled to enforce my security insofar as the commercial part is concerned. Let Lord him take this point with regard to the residential part. I didn't know that there are residential area. If the residential part is concerned, your lordship decides the commercial part, and then
mutation certificate or other things will be there.
I'll have that is the reason I
On
said
that you will can ascertain whether it's actually a dwelling structure or it's a commercial one.
That's the reason why I'm saying that keep it on Monday or Tuesday or whichever day that my lord feels is comfortable. Lord, I'll look into that because
after hearing Mr. Chatterjee, learned senior advocate for the petitioner, and Mr. Kaul, learned senior counsel representing the bank, this court feels that the opposite party numbers 2 and 3.
Yes, bro.
The opposite party numbers 2 and 3.
3 and 4.
3 and 4 are to be heard in this matter. First up, petition is directed to serve a copy of this civil division application upon the opposite parties and file an affidavit of service on the next date. List this matter. 17 তারিখটা দেখুন।
fix a time, not if it's I'm much
3:30. How much time will be taking?
I won't take long. This is a short point.
Yes.
Neither me, Milord. I anyways can't take much time.
3:30 করে রাখুন।
On a Friday, on Tuesday, 7th. Very good.
Monday, 17th is Monday. Monday you have problem, Mr.
Monday week.
Monday week.
Very good. No. Milord, I have a problem today, but I had a problem, but this was urgent, so I stayed back.
17th at 3:30 p.m.
Much
Mr. Kaur, it might be 10-15 minutes
absolutely.
after that because
no issues.
At this stage, Mr. Chatterjee, learned senior advocate for the petitioner, submits that a notice has been issued directing that the possession will be taken by the bank on 10th of August 2026. First of face with the submission, Mr. Kaul, learned senior counsel representing the opposite party bank, upon instructions from the officials of the opposite party number 1 and 2, who are physically present in court.
But you can record the name.
Who are physically present in court submits that since the court is in since this court is in session over this matter, the bank shall not take possession. I'm saying till 19th because till 19th of August 2026.
Much obliged.
Extremely grateful, Milord.
The affidavit of service in respect to opposite party number 1 and 2.
If it is service, filed in court 2 days taken on record. Yes, next. Not today, next. Next. 27, yes.
Lordship had directed to ascertain the name of the advocates appearing. The advocate for the plaintiff has been ascertained. It's Povitro Boito. But for the defendant, it could not be ascertained, Your Lordship. But only it has been come to the knowledge that the advocate is not from the local court.
Advocate not from the local court. This application under Yes. Yes. Who is appearing? So Ghosh, you are appearing. You are appearing. Yes.
I'm for the opposite party. Degree holder, plaintiff.
Yes. What is this? What order you are challenging?
Application under order 97, but our evidence PW was examined and thereafter we got for it. Yes.
You paid for? Yes. Show cause. 27th of May.
7th of May 2026.
7th of May 2026.
Miss case number 95 of 2022.
Oh, miss case number
95 of 2022.
Miss case number 95 of 2022, 7th of May. Always.
Yes.
This particular.
Yes, for the closed. This order has been challenged by us. We are the judgment debtors.
You are the degree holder.
I'm the degree holder.
Oh, you are the judgment debtor. Yes. So who filed this application?
We have filed it. We have filed these.
Yes. Who is OPW2?
For the government of West Bengal Calcutta.
For what?
For your lordship kindly see the notice. At page 19.
19. So for what is the necessity of bringing this authority as a witness? For what? What is the decree for?
Or I tell your lordship the facts of the case.
Degree for eviction.
Yes.
Where the lease. And the lease was granted to us by the opposite party.
Yes.
But subsequent we suffered a degree.
Expiry of lease.
Yes. 89 is suffered the degree.
Thereafter, the up to appeal we lost. Section 47 we lost. But thereafter, the state government in the execution proceeding, state government has made an intervene. They have made an application for addition of party in the execution case. Because they say that it is vested land, they have no authority.
Mr. Ghosh, can you take this point? Can you take the point vested land, meaning thereby you want to take a point that the decree holders did not have title? So you cannot take the plea. So you cannot challenge the title of the inducting landlord or lessor.
Lord, at least not the section we have been. We are contesting the Lord order 21 rule 97.
Maybe Mr. Ghosh, can you challenge? Estoppel is against you. He is the inducting lessor. So now in a way what you are trying to say that he did not have title at the time of induction, that you cannot do.
The act itself. The act itself. That is
Eviction of Unauthorized Occupants Act, let him be evicted. I'm not stopping that. But for that, you cannot stall that.
kindly see notice has been issued.
Maybe.
Against me. And kindly see the.
You contest that proceedings in a different thing. It's a different thing altogether.
But kindly see.
But that is a different subject matter, Mr. Ghosh.
At least kindly see the.
Here is a proceeding, Mr. Ghosh. Only one thing. All questions relating to right, title, and interest between the parties. So here you are the judgment debtor. You are not a third party. So the scope is very, very limited. Whether you at all have a right under Order 21, Rule 101 is the main question, perhaps. But even though I cannot say, because of the expression any person. There's two Supreme Court judgment which has explained the expression any person to men, including the judgment letter. You have filed, no issues on that. But you cannot take the help of that notice, and for that bringing that government
Not
official.
only that, Lord, kindly see the earlier order passed by this court, by the coordinate bench of this honorable court. Lord, your lordship, kindly come to page 17. Our section 41 application, Lord, against that division has been dismissed, and while deciding the same, it has been observed. Lord, kindly come to page 17, Lord, last two paragraphs.
Yes.
Perusal of the impugned order.
This is against 47.
Yes.
Yes, on perusal of the order impugned.
Did not find any material irregularity or illegality in interfere with the same, particularly for the reason that the right to service the petitioner and the opposite party has realized. So far as the issue is concerned, the application filed by the state is well. The executing court while dealing with the state application by the state in its application. The executing court therefore is directed to the hearing of the application filed by the state and not thereafter the execution. That is the difficulty. We point out that let it be decided. Then if I am thrown out, I am thrown out.
Mr. Ghosh,
That
can
is
you
the
take
direction,
the
Lord, at
point
least.
of vesting? Is it open to you to take the point of vesting? Vesting meaning thereby, the basic thing is that you want to deny his title as a lesser, which you cannot do under section 160.
But so far, Lord, this order has to be carried out.
Ghosh.
This,
Yes,
Lord,
Mr.
I
Dev.
have no right.
What were you doing?
Also, kindly sees the other paragraph at page 17. The upper paragraph. It has been decided section 4. Also, kindly appreciate the background facts. In 1957, the lease deed was executed. In 74, the lease deed came to an end. Eviction suit was filed in 84. 89 suit was decreed.
Oh, this is an independent
Yes.
cause.
And 92,
Mr. Ghosh, previous paragraph says independent
everything.
cause.
It has been settled by the this honorable court, and they have not challenged this order, and they suffered an order before the honorable Supreme Court, and the honorable Supreme Court imposed a cost of 1 lakh
Ghosh, you
rupees.
cannot take this.
This is abuse of the process, my lord. Also, kindly appreciate.
Let it be decided.
It's a whole
You
thing.
do not have any right. You do not have any right.
And to
You cannot
procrastinate.
now challenge that vesting, Mr. Ghosh.
Section 47 remains. This order remains.
Another thing. Lord, all on a sudden, it is my application. They mentioned the matter
Upon
before
notice.
the application.
Upon notice. Yes, upon notice. Notice to the.
No.
Upon notice.
No notice. All on a sudden found that.
Also, kindly
the matter-
Sir, they please show it to Mr. Ghosh. He will not deny.
He is not our class. He is not our class. He is not our class. All on a sudden, today, my lord, have found that the matter has been appearing in your letter. It is our application, we have not mentioned. Whatever, no, that is the point. I know that it is in between the parties that is settled.
No, for that, if you say, I can keep it on the next day, Mr. Ghosh. But if you are ready, this is the matter. If you really say
That's
that.
why, my lord, kindly see. I have noted from my lord's record that this is the application because I had no knowledge about the matter as was mentioned.
Thrice notice was given.
Mr. Ghosh, if you say that you are not ready because the notice was not properly
But it's
served,
only to
then I can keep it on.
procrastinate the issue. It's only to procrastinate the issue.
Then I can keep it on Monday. So,
That
but
I know, my lord, but I am ready. That's why I'm not.
Thrice notice was given. Thrice.
Not to us.
now, Mr. Ghosh is now saying.
Brought the record also.
All right.
Lord, in the other brief, I have noted from your lordship's record. This is the.
So, Mr. Ghosh, this is the issue. This application Yes, who is appearing?
I appear for petition.
You are for the petitioner.
Subject to correction, my lord, I cannot pray for a stay at this stage. I am seeking for enhancement
Of?
the interim maintenance given to him. Lord, I have information to face. The opposite parties are appearing.
Well, I got the information the matter is listed, so my lord.
Then, my lord, then I can possibly press.
No, my lord, because I don't have the petition.
But kindly take. My grounds are three, my lord. The order impugned 8 January 2026 takes into consideration few things erroneously and gives me two things. A, interim maintenance at the rate of 9,000 rupees. B, entirety of litigation costs of 10,000 rupees. Now, save and accept this litigation, which of course could not have come into see the light of day at that point in time. 3 litigations pending. 10,000 rupees litigation costs given to me, which I am saying is incorrect. Miller will also see that I have filed an application for transfer. I shall take Miller through each and every paper and just indicating the facts. The opposite party, Miller, the husband, is a government employee with a salary of in hand 62,250.
Salary of?
62,000 odd rupees. And interim maintenance given to me 10,000 rupees. I am interim maintenance 9. I am thankful, Miller. Maintenance given to me is rupees 9,000 rupees. Interim, of course. Yeah, 110. Milord, if Milord kindly takes the salary slip, Milord, I will find that at page 42. This, Milord, is for the month of March 2025, which the petitioner last had. Milord, my lord has it.
Please give me a minute.
Yes, I'm sorry.
Yes.
May I just show a few documents, Milord? If Milord kindly takes page 42, this is the last salary slip known to me. That is with the opposite party.
Yes.
Milord has page 42. My lord will kindly see that
This was produced before the court below.
Yes, but what was not considered is the all railway salary slips. One is allowables and one is basic pay. The salary slips are decided. The learned judge, the honorable court below, my lord, takes into consideration that over and above this, there are expenses of house and allowance, which the opposite party has to pay. But admittedly, according to their case itself, they are residing in Shonarpur or government quarters. So, my lord, that is negated. A large chunk goes on that. The affidavit of assets submitted by the opposite party before the learned court below, my lord, which starts at page 84, my lord, palpably in column number 4, says that he lives in a rented house. Not a government quarter it is preposterous to assume that I pay rent for a government quarter. I am given house rent allowance, which is by I, my lord, I mean the opposite party. The opposite party is given a government quarter in Shonarpur. Admittedly, they say in their divorce petition that they have a government quarters. It is an admitted position. The rented house component
from the affidavit of assets and the quantum deducted is minus from his salary. So to understand how much the opposite party earns, the finality of adjudication is basis that the
No,
opposite.
that rent which is being deducted, that should not be deducted.
Subject to correction, I asked myself
The
specifically.
rent is not to be paid.
He has government body, he is not paying, and HRA is given in his salary.
For that, rent is not to be paid.
Kindly takes the salary component once,
Yes.
House rent allowance is already given here. Subject to correction, of course.
Page 42.
42, my lord, yes.
Where is the house rent allowance?
Kindly give me a second, my lord. I will kindly come to recoveries.
Yes, that is recoveries.
Yes, this is what the employee is subject to the test that my lord puts me through, of course.
Yes.
What
So that is not deductible according to you.
This is they already deducted. I am
Yes.
not saying that,
So,
but the
so
quantum,
these are the deductible amounts.
quantum
These are-
showed before the code bill is 20,000 on discount on rent. That is where I draw issues, my lord.
No, 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 no. Please see the finding. The code below has arrived at, please see page 5.
Lord, may I just juxtapose?
Page 5, his gross salary is 60,435. So net is 54.
Yes. My lord,
So the
may
code considers on 54.
May I just place this in comparison with the affidavit of assets, which the learned code below draws its comparison on, my lord. May I just, for one moment, if my lord kindly takes the order impugned placed before page 84, my lord, and page 84 together, my lord. Yes.
Yes. 84.
My lord kindly takes the entry number 7 at page 84. This is what possibly subject to correction, my lord, had a bearing on the learned code below.
No, 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 no. That has not been considered. No bearing. Please see page 5.
Of the
The
order
court considers, yes, court considers that his earning is 54,000, not deducted 8,000. Please show me the finding. Yes, deducted 8,000. Nowhere.
Not kindly.
Court considers on the basis 54,000.
Yes.
Court has not deducted 8,000.
No, that is, if I fail on
If
that.
8,000 is deducted, you would not have got 9,000 also. 8,000 was deducted from that, you would not have got 9,000 also. That has not been deducted.
Yes, sir. May I just come to the second prong of, if not subject to what?
125, you are getting anything?
No, nothing. No 125. Their application for divorce.
You are proceeding under 125.
Their application for divorce. I have filed 24. They have filed section 13.
125 of CRPC.
I have not filed.
You have not filed.
I have filed section 24.
Yes.
And
yes. How much do you want?
I am getting 9,000 rupees. There was a application pending before a different court. I filed a transfer. I filed a transfer.
That's different. How much do you want?
If subject to correction, if the test that Milord puts me 20,000 subject to
20,000 out of 54,000.
Milord, it is still lesser. Milord, he has not just that property. He has rental income, which according to me is upwards of 20.
You could not prove that. That's
I have not been able.
Then, if you have not proved that,
I have not been able to.
He has also alleged that you have income, so that can be taken. Yes.
Milord, may I negate that for the time being? May I negate that? Admittedly, Milord, he has a father who was a government servant and is earning a pension. The mother is taking benefit of that pension. I am a pass course student, Milord. I have no income of my own. I had also, Milord, personally sought for the income tax returns of my client when they had come to me. No income tax returns are filed. So there is no income that is given for taxation. My income as on date is what my father gives me as my pocket money. I have no means of sustenance save and except the house that I am living in my father. Milord.
What is your monthly expenses now?
Milord, I have claimed that is 31,500.
So that's your expenses. How do you bear that without having any income?
I have
31,500 per month,
I
and your
cannot-
husband is not getting that.
Milord, I cannot go.
So you
what is-
must be having at least 31,500 income
I cannot
from
go what
various
is-
sources.
I cannot go what is beyond the pleadings.
Be
Milord. I cannot-
careful while mentioning the expenses in the affidavit of assets and
Milord,
liabilities.
Had it been me, Milord, I was mentioned it differently. I have sought for
So
that.
when you
10,000.
claim that you are bearing that
is
expenses, then you must be having some source of income to maintain
Because I have to
and spend that.
I have to travel to a different district to obtain different legal counsel to contest an application that they have filed. That is one of the primary sources of expenditure that I have, Milord. dates are given on a bi-monthly, on a monthly basis. Bi-monthly would be incorrect. On a monthly basis, I have to engage counsel in a different district, not Kolkata.
For that, section 24 is there. If you can,
No, I have gotten one time 10,000 rupees. One time, not on a monthly basis. But I am seeking, my lord, that I am to be
yes. What do you
given
say?
those- not served. They just they're not on caveat.
May I come back with them? May I come back?
They're not on caveat. Can I just say two things? My prayer would be before this honorable court that I am to be given a situation at parity what I was prior.
At
If
parity, what it was?
I was prior to me leaving my matrimonial house at their instance.
How much you are getting there?
You know, I was enjoying the benefits of me having a husband who was earning upwards of 62,000 rupees.
Now, how much you are spending at that point of time when you are living
Those
with your
documents are
husband?
I cannot say that off my cuff because those documents are not on record. I cannot say that.
How much you are getting in your hand when you are living with your husband?
How do I make that sentence? It becomes a difficulty. Not what I am stating is not anything that I say on that.
So same status what you are saying. So you have to say how much you are
My
getting
reasonable
in hand
understanding,
at the time when you are living with your
my
husband.
reasonable understanding is that 20,000 rupees would be enough for her sustenance per month.
Sir, 20,000 out of the income of 54,000 without any basis, sir. So one third to 1/5 is the
Come back to page 42.
1/3 to 1/5 is the basis.
Yes.
So even if we take the average of 1/4, even that does not come to 20.
54,000 no longer the basic as on date. It's much more enhanced. Kindly comes back to page 42 once.
All right, so you can file an application for enhancement because I have to consider on the basis of that.
You know, this is of October 2025 as on date in terms of this payslip. It is enhanced.
So October 2025
March
is
2025. I'm sorry. March 2025.
how much it will increase?
You know, I have taken out the circulars, my lord. Sir,
What is the stage of the matrimonial suit?
evidence
For
is going on.
evidence.
My affidavit on evidence is
Lord,
fine.
Here I join.
If I'm
you to-
expediting, please take instructions.
She is not appearing for 3 times. No, 3 occasions she has taken
I
adjournment.
will expedite. I will fix. I will
Great.
direct the
No
matrimonial
adjournment on
suit
the
to be
white flag.
concluded.
Yes,
Please take instructions as to the alimony, how much you are willing to pay. I will fix a time.
Make it in a time bound manner. My prayer before this honorable court.
Your evidence concluded in the
My
suit.
evidence complete, cross-examination concluded.
Yes.
Concluded. All right. So I think 1 month suit can be disposed of.
Yes, my lord, then my remedies. Then I am adequately satisfied. Yes.
Have you paid this? Are you paying this amount?
Yes.
I am paying. I think that can be without going into that. I am disposing of the suit within 1 month. It will be unnecessarily dragging this
Yes,
proceeding.
my lord, then a finality may be.
Yes.
Next date is 17th September 2026.
This application under Article 227 of the Constitution.
seek for enhancement of that 5,000 rupees to 10,000 rupees. I should be very candid. To travel 2 districts to contest this litigation.
Only 7,500 crore. Yes, next. Fixed matter. Call this.
Your Lordship calls the fixed matter item 78 I had mentioned in the morning for extension of the interim order. 78 of the Delhi list.
78. Who is your other side?
My other side is here. I have served the BMC through email also. Mr. Anish Mukherjee is there.
This item number 78 at or record করে দিন after.
which directs the Vidhannagar Municipal Corporation to, after demolish, the report to be filed before the Registrar General. Already 2 weeks.
Let me see, it's appearing in the list. Yes. Next, call the fixed matter. এই দুটো তো আলাদা ম্যাটার নাকি? Same matter or different matter?
No, these are different matters.
Matter can stand over for some time. Why I'm saying?
It can stand over.
Why
No,
I'm saying?
because
Yeah, but I am challenging an order passed ex parte. Now, in section 9, now, the order, now matter has been completed, hearing is completed, and next date of delivery of judgment is on 9th. So this matter can stand over till that day.
Stand over till instructions.
No, I'm not saying.
Lord, I am appearing with Mr. Sharkar in this matter.
Yes, Mr. Sharkar, what do you say?
Well, I am saying the matter.
This is from an interlocutory order. Final hearing of the appeal is over. Then kept for judgment. Nothing survives of this application. If Narasimhan is aggrieved, he can come back from the final order.
Mr. Nag, what remains? The appeal, after the appeal order is passed, you have your evidence.
No judgment is passed, then what?
What no judgment?
I tell you now, the case.
Lord, it is his employee basically.
2023, I am appearing. Suddenly,
on 19th is fixed for judgment.
It has been fixed on 19th of August. It will be. What have you challenged here?
Can you see the impugned order?
What is the impugned order?
Impugned order is but an order to stay. That has been passed.
All right. After the appeal hearing, nothing remains with the stay. Asun. The all the rest matter.
Well, only one thing. There was no unconditional stay. Stay of a notice was there. Only not stay of the order under appeal.
From 2023, no interim order was even.
Unconditional stay of operation of the notice.
Of a notice.
Unconditional stay of operation of the notice. Unconditional stay of operation of the notice. That's your submission. I'm recorded Mr. Nag's submission. As a Mr. Nager, ওই submission টা উনি না হলে একটু মনে কষ্ট পাবেন। সরকার লানের senior advocate appealing for the opposite party.
Item 28, that minor child's matter, where parties have sat and have arrived at some sort of a middle ground. Clarifications could be given to the impugned order and the matter could be
not today, come on Monday. Yes, Mr. Dotto. Yes, Mr. Dotto. Yes.
I beg to appear, my lord, for the opposite party.
My lord, I'm being led by Mr. Aniruddha Chatterjee. He's appearing virtually, my lord.
Your lordship, my lord, had the
Lord, before my learned senior friend starts, he made a submission on the last occasion about limitation.
Mr. Chatterjee, only difficulty, how much time we will be taking, because I have some
but I'll indicate one thing, but I think I should bring it to the notice of the court as well as Mr. Chatterjee. I have some time to spare just before coming to this court. But I find, my lord, this appeal has not been filed, my lord, under the PPE Act. It appears so. Mr. Chatterjee may take instruction. Kindly have a look.
Appeal was filed, not under PPE.
It
not under
appears
section.
so. It appears so. Under order 41, it has been filed.
Order
41.
Nomenclature doesn't matter. Nomenclature doesn't matter at all.
And also the memo of appeal also, your lordship, fine. Mr. Chatterjee may take instruction.
And kindly, first of all, my lord, but the revision application should be dismissed here and now.
No,
This is the revision application on that ground also. Because the way it's been drafted, my lord, it's not a revisional application.
No, only one thing, Mr. Datta, miscellaneous appeal also, order 41 provisions
the same judge.
will also apply.
Will apply.
Now,
Yes, why I say
it's
this?
a miscellaneous appeal.
Why I say this, my lord? The memo of appeal doesn't say that it is under the PP Act. The stay application also does not refer anywhere that.
But if the order of
No.
the estate officer, what's the
No,
real
it's-
problem?
That is why, my lord, on the first day, the learned judge says that the appeal is in time.
No, the
Please,
period of limitation is same.
No. Here 12 days.
12 days. From the date of
Appeal is 12
publication.
days.
12 days from the date of
And
publication.
this has been filed on the
The date
22nd.
of the order.
So the court was under the impression 30 days.
30 days.
I don't want to.
Mr. Chatterjee may take instruction unless he's already prepared on this point.
I am prepared on this and I'm ready to submit on that.
Yes.
Let Mr. Datta take up this point, or I'll address him on that.
But your lordship may kindly take me
Yes, your
page
lordship
number.
on that, not him.
Something is going to happen in this weekend.
No, below they have sealed it. I can do nothing.
But I have taken possession under section 150. Under section 151, Millard, they have the learned judge Millard has passed an order directing repossession. Therefore, let this continue till such time your lordship takes up this matter.
Yes, let them start paying me money now. Now, if this is what is good for the goose, is good for the gander.
No, he was not in occupation.
I was.
Sir,
Arre? Then
he
how
was
from
not
whom
in occupation where the eviction order says so.
But he's taken possession from me. Lord, I understand your lordship is in a little bit of a problem today.
Yes, I have an administrative
I
meeting.
understand.
That is the
Lordship,
only.
Monday at the top. if
No, I've asked them to take when it will be scheduled to
No,
start. Because it has been preponed.
Nothing's
Because
going to
the
happen
other
on the
members
weekend.
have also risen or not. So
I
I can continue.
The more senior your lordship becomes, the more administrative committees your lordship will be inducted into.
Sheta, Millard, I do not wish to, Millard.
No,
But
only one thing, Mr. Datta, what is their limitation point was decided, or some observations.
Millard keeps it Monday at the first plot if it comments to your lordship.
Monday ta ki ache?
Millard, that's because they've taken possession from me.
No, because Monday, I think, Mr. Chatterjee, your another matter is fixed on Monday.
Millard, your lordship fixes this first because this is important because my entire.
All your matters are important.
No.
Mr.
But
Chatterjee,
Millard, I am a very unimportant
on
lawyer.
Monday, you give me a list in order of priority.
Your lordship fixes it.
No, you give a list in order of priority, which one you want to move first, which one you want to move second. Please give an order of priority.
This one first. This one first.
Monday.
Mr. Chatterjee, May I request you to concede for Monday week?
Milord, I never say no to Mr. Datta. He knows and he does that deliberately because he
So,
knows.
no, Monday week is Mr. Chatterjee's another matter is fixed.
Tuesday week.
Tuesday week.
Milord, kindly. Milord, this will take 10 minutes of my lord's time. Let Mr. Datta finish. I will take 10 minutes. Kindly keeps it on Monday in the morning. Kindly. 10 minutes, Milord, not more than that. Because this is
Looking
his
at the appearance of the councils
Milord, Mr.
morning,
Datta's
you will be very busy in the morning. Please do your other
I
assignments
can assure
in the
your lordship,
morning.
Milord, I will be
কবে
here with
ফাঁকা
your
আছে
lordship. This was done, Milord, very, Milord, by using trickery, if I may use the word.
কবে হ্যাঁ? Wednesday,
Very
how
well.
are you placed?
I'm available.
But then Mr. Nag will do the matter.
Why? You will not be
No,
there.
I'll be not here.
You will not be
Mr.
there for
Nag
the
will.
entire week. Mr. Chatterjee, then I'm keeping it in the next week.
That is right. Then let them pay me money then. The problem is, Milord, kindly appreciates here. Milord,
I'm keeping it, Mr. Chatterjee, I'm keeping it on 18th.
in the
Due to
meantime, they are enjoying
due
the
to paucity
Relevant documents regarding income tax return, GST returns are, my lord, within the premises.
No, if you want to take out that, I told Mr. Chatterjee, he said no, he wants to get the possession in its
Because
entirety.
now,
If you
because
want
it's
that
taking
income tax documents and other important papers, then I can request Mr. Datta, please allow them to take out those.
very
So
well.
without then, Mr. Datta, please ask your officers if they make a request, so that can be done. I'm not passing any orders to that effect.
But only thing that instead of 18th, could it be 17th or 19th? Which
17th, Mr. Datta has fixed another matter.
Then
18th, he will not be here.
No, 18th we have got 3 matters fixed in the second half.
So this is at 3:30 or
I'm
May not
keeping
get
it 3:30.
May not get over. One is a
19th কি দেখুন হ্যাঁ 3:45 3:45 it's another matter is fixed.
Could it be at 3 o'clock, subject to the business permitting?
20th there is 20th.
but pendency, Milord, there is no interim order. I do not want to, Milord, I don't want to take out those documents for the moment.
Mr. Chatterjee, I have not passed any orders. If you
Very
are,
well.
your client
Very
says, please, I have Mr.
Lordship
Datta
has not
here. He
passed
has
any
agreed
order,
to
Milord.
that. Please write a letter to Mr. Datta's officers. He will instruct his officers to take out only that in presence of.
Grateful.